Welcome to the regular meeting of the San Francisco Ethics Commission. This meeting for May will start. I'll call the roll. Commissioner Rennie. Here. Commissioner Chu.
Here.
Commissioner Kopp.
Here.
All right. And we're still waiting for the mayor to appoint our fifth member. This evening, Director Pelham is under the weather, so she's not here for tonight. And we'll be going forward and having the presentations by members of the staff. First, we'll go to the item number 2, which is public comment on matters appearing or not appearing on the agenda.
Chair Keene, Commissioners, I'm Larry Bush, speaking for Friends of Ethics. I wanted to briefly address the controversy over the Brown Act and the allegations of a violation by the Commission. I'd like to urge that Deputy City Attorney Andrew Shen clarify to the Commission and the public the provisions of the Brown Act, specifically dealing with items that are not on the agenda. I have a copy of that section of the Brown Act, which explains that there is a specific exemption when an issue has arisen after the agenda was created and when it's important for the Commission to act and for the Commission to then vote that it's going to act and then do so, which is exactly what happened. Mr. Shin offered public advice to the Commission, which omitted all mention of this provision, and in turn his comments are being cited in formal criminal complaints against the Commission. Does he now elect to amend or retract his public remarks? For the record, the timing of the issue is dispositive. The Planning Commission agenda was just that issue was not made public until the actual day of the Ethics Commission meeting. A planning commissioner, according to the Sunshine Ordinance responses, did not notify the other planning commissioners or the planning director of any potential conflicts. And I have for you copies of the Sunshine responses from the planning commissioners saying that they had no advance information or any information whatsoever about this new assignment with Spur for a planning commissioner. So the only formal notification that the Commission received was the letter from the Ethics Commission suggesting a recusal. The Deputy City Attorney, speaking at the Planning Commission, said that there had been undertaken no independent investigation of the facts in the case, but merely had interviewed the Commissioner and accepted her statements. If an interview had taken place and any investigation had taken place, they would have seen that that Commissioner was a member of the board of Spur for the entire time that the negotiations were underway for her to take that job, and at the time that Spur adopted its policy, which was at issue. There's a larger question, which is that in most protocols, the Deputy City Attorney offers legal advice in closed session and not in a public session. This was an exception to that, and perhaps Deputy City Attorney Shin would like to clarify why he didn't suggest that they take a moment for a closed session to discuss it, but instead put it out. It became the basis for the criminal complaints that are pending before the District Attorney and the Attorney General. Thank you.
Thank you, Mr. Bush. We have further public comment?
David Pilpel. With some trepidation, I comment on the matter that Mr. Bush just raised. I don't want to rehash what happened last month, and I'm sure that'll be dealt with in some other forum. I do believe that the Commission could have made the appropriate Brown Act findings, that circumstances arose and that putting the matter over would do serious injury, but the Commission did not make those findings. So the record stands as it is, and we'll see where it goes. That's all I have to say on that matter. I hope that Leanne feels better, and I'll have further comment as we go along through the meeting. Thanks.
Thank you.
There's nobody else commenting. I'd like
Commissioner Cobb
to be heard and associate myself completely with Mr. Bush's comments. and to note that the chairman uttered facts which give rise to either one or maybe two of the exceptions in Government Code section, whatever it is here, 5498.2, subsection C, D, whatever, 1 and 2 and 3. And I am not only dismayed, I'm surprised. Our deputy city attorney has a number of years on me, and in the back of my aging brain was the thought that after he spoke, that there are exceptions to that notice in the agenda provision. And I'm also surprised because knowledge of the Brown Act for an attorney assigned to this commission, which includes knowledge of the exceptions, it should be a fundamental part of the quality of service from the city attorney's office. If it happened in private practice, let me tell you, you might be looking at malpractice to give that kind of advice. I don't care if the advice is given publicly or privately, but it's so easy and it's so fundamental. And again, the chairman's articulation of the various reasons which impelled the adoption of an action to send a letter to the commissioner in question will stand in any court of law or in any administrative proceeding. And it's just an ABC of the Brown Act, which has caused a lot of unnecessary time and effort on the part of public officials. You got to go through this whole routine now. And the AG and the district attorney, who you might hear from in about 3 years based on past performance, and then the newspaper stuff, because, look, reporters, for the most part, are trying to do their best at understanding legal situations. Tempest in a teapot. Thank you, Mr. Chairman.
Thank you, Commissioner Kopp. Commissioner Rennie.
May I just say in a few words, I don't think it's productive for us to be criticizing the deputy city attorney who, since I've been on this commission since 2012, I think has done a splendid job, and I think the circumstances were such that he should not be criticized.
Thank you, Commissioner Rennie. I'd like to just make some comments just to frame what we're talking about for the understanding of the public and general understanding of the record, because someone just tuning in on this session obliquely would be at a loss as to what it is that we're addressing and what the comments of the public have addressed and what Commissioner Kopp has addressed as well. And that is that at our last meeting, it was brought to our attention during the meeting that a particular individual who had been given the job of executive director of a private organization that engages in lobbying and other things, mainly on behalf of developers, and had taken a position on a particular housing member, was also a member of the Planning Commission. And so she was holding these two positions at the same time. We didn't address the propriety of that in itself, but it was brought to our attention at the meeting that a vote was coming up in 3 days on a particular very controversial, very significant housing measure for the city. And she, as a planning commissioner, was going to vote on it. We raised that issue of whether or not we should ask her to recuse herself because that appeared to be a clear conflict of interest. Just asking her to recuse herself from that. The question of the Brown Act came up. I ruled that, I specifically ruled that because this was a matter of some exigency, I used this term exigency at the time. The Brown Act talks about emergency. Exigency, as I understand, is a synonym for emergency. That because we would not meet again, and that this was something that was occurring in 3 days, and it was very important and an emergency for us as the Ethics Commission to address a significant ethics matter that was occurring in San Francisco, and that because of that exigency, which is what the Brown Act the emergency, which the Brown Act allows action upon, even though it's not agendized, that I ruled the matter was properly before us and that we should go ahead and discuss it and vote whether we would send her a letter saying that we think she should recuse herself. We discussed it. All 4 members of this commission unanimously are of the view that she should recuse herself. We all voted unanimously to send that letter. The letter was sent. After that, an individual whom I have no idea who she is or what, raised a complaint against the commission under the Brown Act with the district attorney's office and the attorney general's office, as is her right to raise it. I put in responses. I wrote responses to both of those complaints, put them into the district attorney and to the attorney general, and also I wrote a response to the Sunshine Ordinance Task Force, which also she had complained to. I expect to testify before the Sunshine Ordinance Task Force and also argue the position of the commission when that comes up, and I will do the same for the district attorney or for the attorney general. Like Commissioner Kopp, I'm always very hesitant, having been burned over 40 years as a trial lawyer predicting the outcome of litigation. But I think in this case, I'm pretty confident we're going to prevail in this case. We did not violate the Brown Act. We were acting properly. We were acting pursuant to an exemption in the Brown Act. We were doing our job for the city and county of San Francisco on a significant ethical matter. And I feel okay about it, and I'm sure my colleagues feel okay about it. Anyone who has different position or thought on that, they're certainly entitled to have it. But I just wanted to address that, to put that in perspective as to what it is that we're talking about up here.
Mr. Chairman, is it relevant now, or is it later in the meeting to raise the other question again, which we've gotten a legal opinion on from counsel as to whether the fact of whether a legal opinion is written or oral is within or not within the attorney-client privilege?
Well, I think we could raise that now, but why don't we, since we're going to be talking generally about the agendized matter having to do with legal advice to us, okay, why don't we include that specifically at that time of that topic, Commissioner? I think it would be smoother if we did it rather than dovetailing it onto public comment as we are.
Thank you.
All right. Any further comment by any of commissioners? All right, well, with that, then, we'll go to item number 3, discussion and possible action on the draft minutes for the Commission's April 24th, 2017 regular meeting. Are there any comments, corrections, additions, anything to brought out relating to those draft minutes?
Mr. Chairman, there are a couple of misspellings. One word is plural and it should be singular. I confess I left my minutes in my office, but I'll supply those. There's nothing of substance.
Very well. Any other comments? Yes, Mr. Bush.
Yeah, thank you. Mr. Pelpel pointed out to me that the minutes appear to reflect only one vote about the letter going to the planning commissioner.
One person's vote?
No, just one vote by the commission. I seem to recall, and I'm asking that it be reviewed in the recording, that there was a discussion about whether or not to move forward, and the agreement was yes to go forward, and then there was a second vote about sending the letter. So there would be two votes, which is what the Brown Act called for.
Well, you're correct. We could essentially what happened. There was the question of whether we should go forward. I ruled that we should go forward if there were no objection, implicitly if no objection, which would be in the form of an authorization or vote by the commission. So there were two actions.
And I just wanted to make sure that the minutes were not used in a way to undermine your point.
I thank you for that, and I think that is important, particularly in regard to the observation made by Mr. Pilpel relating to a particular set of procedures in the Brown Act exemption, which, in my opinion, we met those procedures completely. Mr. Pilpel, I'm not asking for a response.
No, but you're taking public comment on the minutes.
On the minutes, okay.
Yes.
I didn't.
Very good. David Pilpel, two things. Yes, I believe that the bottom of page 2, that the tape should be reviewed to clarify what happened. I think it's important for the record. I recall it one way, others may recall it a different way. I think in general the characterization in the draft minutes is accurate. But I also will have some non-substantive edits that I can provide to staff and perhaps can be incorporated as appropriate, just some spelling and whatnot.
Very well.
Actually going through the minutes. Thank you very much.
Thank you. Any further comment on the minutes? All right. Is there a motion to approve the minutes?
So moved.
A second?
Second.
All those in favor of approving the minutes, please say aye.
Aye.
Aye. The minutes are unanimously approved. Okay, now we'll go to item number 4, presentation and discussion of staff report on filing process for 2017 annual statements of economic interest, Form 700s.
Chair Keene, Commissioners, and members of the public, good evening. I'm Pat Peterson, and I am a member of the Education and Compliance Division at the Ethics Commission. Tonight's report is to provide highlights of the programmatic information and the operational updates regarding this year's, the 2017 Annual Statement of Economic Interests, otherwise known as the Form 700. Joining me tonight is Gayatri Teikendil, and together we're going to be presenting a report that includes detailed information about the status of the Form 700 filing this year. We're also going to talk about the initiatives and the outreach that we have engaged in this year to reach out to people who file the Form 700 and assist them in complying with the filing requirements. Following that, this year we undertook a survey process where we surveyed both filers and the elected and assisting city officials who help filers file their Form 700. And we have for you tonight our observations and our takeaways from what we learned from people who talk to us about what they file, what do they understand, and how can we help them increase that compliance level. So again, for an overview, we'll talk about the annual filing status. We'll talk about the statistics, the number of people who filed, the number of people who filed late, the number of people who filed who haven't yet filed, and what we're doing to address those individuals. We'll talk about our outreach and support that we undertook leading up to this year's filing, the number of people we met with, how we reached out to them, whether in person, in meetings, or through our website, or in writing. We'll talk about the survey that we sent out leading up to the date of filing and following the filing, and what we learned. What did we hear? What did we see? And more importantly, what did we learn? What are our opportunities and our takeaways so that we can bolster areas that we should increase our outreach, for example? So, for the annual filing status, this year, the annual statement of economic interest, the Form 700, where certain individuals at the city disclose their financial interests as it relates to their jobs and whether or not their jobs are affected by their decisions. This year's due date was April 3rd, and that's because April 1st, which is the date that is usually the filing date, fell on a Saturday. So the filing date fell to the next business day, which was Monday. We have two types of filers. We have people who file electronically and people who file on paper. Currently, the people who file electronically are our elected officials, our commissioners, our board members, and our department heads. They're required by the San Francisco Campaign and Governmental Conduct Code to file electronically. They may not file on paper. We have a second group of filers. They are designated employees, individuals who, in their day-to-day jobs, make decisions that could affect their financial interests, and they're therefore required to disclose any financial assets related to their decisions. Of our electronic filers, we currently have 505, and for our paper filers, we have approximately 3,000. So this is a snapshot of the e-filings in 2017. I want to draw your attention to the graph on the left. Now, what it shows is that from 2014 to 2017, we've gone from a high of 93% in 2014 of on-time filings, total filings, down to this year, 88. And we're trying to close that gap. We're working strenuously to close that gap. And what you'll hear in tonight's presentation is how we're addressing that through education, through outreach, through, if need be, enforcement. So this graph is just one of the many types of data that we're able to collect. And in the report that's available before you and on the table, you'll see a number of graphs and information that we're now able to collect because we have this information available and it's filed electronically. For example, we can see, and this graph is in your report, we can see what we've already felt in our gut, that about 3 days before filing deadline, there's a whole lot of activity. Now we can quantify it. And that's important because it's one thing to say to somebody, we need to ramp up. We're going to be so busy. And now we can say, we can tell you, and let's respond to it. This particular pie chart is, again, something that we were able to collect from our data, and it shows that 65% of our e-filers reported some economic interest. In other words, they're filing the schedules that attach to the Form 700. They're disclosing business interests, they're disclosing property owned. That is information that we can now see, and when we can see in the larger section of the lighter blue, 65% of our filers are filing schedules. We can teach to that. We can educate to that. We can provide information about what is disclosable, and it makes our data better. This slide, now we're moving into talking about late filers and non-filers. We do two things, and this is according to state guidelines. And we follow the guidelines for smaller cities, that is, cities with fewer than 50 filers. We adhere to a framework of first notification within 30 days. We tell people, you haven't filed, you got to file. 60 days later, we do the same thing. You haven't filed, you got to file. After that, we move into 2 levels of enforcement. When somebody filed, but they filed late, we handle that internally with the Enforcement Division here at the Ethics Commission. If they haven't filed at all, straight referral to the state, and we advise them that the fines can go up to $5,000 per violation. This is a slide that talks about our outreach and effort as we try and support our filers. This year, we, in the first turquoise box, which is a white font, which will change next time, it talks about the first time that we've reached out to the people who actually file. Typically, we have liaisons within the departments, and we say, please send the Form 700 out, give the instructions, have it back to us by this date. We went a step further this year, and this year we reached out to the people who actually file. We held 3 sessions. We had 50 attendees, and it was a darn good start, and we have some feedback to share with you about that effort later. We also had, in the dark blue box, our 2 regular sessions where we reach out to the individuals in the departments and say, here's what you need to do. Get the information out about filing, collect the information, refer any questions that you have to us, we'll help you. In terms of filer support, we reach out in several ways. We reach out through the filing officers, we reach out electronically through emails, we hold the trainings, we talk to people when we can. And then our last effort at support is we're there on the phone. We take phone calls, we answer emails, we do what we can, but we try to be available to the filer. And now I'm going to ask Gayatri to go over the section on outreach and support that involves our new online presence and go over some of the stats that we were able to collect.
Thank you, Pat. Good evening, Commissioners. As Pat mentioned, this year, we've tried many different things to provide better support to filers and filing officers through information sessions and one-on-one support. One of the other areas that we really prioritized this year for outreach is our online website. We know that we have this tool that's readily available and easily accessible to filers and filing officers. So we wanted to make all of the resources and tools available in one place. And as you're aware, with our new website, we typically provide timely reminders on our homepage, and that's a way for people to kind of remember and understand upcoming requirements. So in February this year, we had a homepage banner focused on Form 700 filing deadline, which took the visitors to a landing page which contained all of the information and tools related to the filing requirements. And ongoingly, we kept enhancing those portions of the website as and when we had new materials, maybe presentations or frequently asked questions. These were some things that we put together later on as we went through the information session process. We added them back onto our site so that wider audience and wider members can access them. In addition to the website, we also sent out notifications through our IP list and also through the social media, through Twitter, Facebook, trying to reach different filers, trying to reach different audience and spread the word about the deadlines. So that's something we focused on this year and we would want to continue to do ongoingly for all of our programs. Yes. Moving on to filer survey. As Pat mentioned, we wanted to get feedback from filers and filing officers on their experience with the annual filing process and also better understand their needs. So we created 2 surveys. One was focused on filers and another one for filing officers. And we sent out the links, these are online forms, through filing officers to the different audience. And this was soon after the deadline, April 3rd deadline. We got feedback from both the groups. So we had 138 filers respond to the survey, which included paper filers and electronic filers. So the chart there shows that majority of the respondents were paper filers, about 85% of those who responded to the survey. And just as a reminder, we have a total of about 3,500 or so filers. So the response rate represents about 4% of the target group. And on the filing officer side, we had 20 responses to our survey. And majority of them, about 65% of them, were filing officers who supported paper filers and electronic filers. So we wanted to get a better sense of who are the people responding to the survey so that we can better understand the context of their comments. We also wanted to know whether the filers and filing officers had previously participated in the program, or are they new filers and filing officers. Most of the filers, about 85% of them, had previously filed Form 700, so these were experienced filers. And filing officers, about 90% of them had performed these filing officer duties. So these were the people who provided us their feedback through the survey. Now, looking at just the overall experience, we wanted to, we provided them an opportunity to give us a rating between 1 and 5, very poor to very good, just to get a sense of how do they perceive this process. On the filer side, most of them were either average or above. We did definitely have some filers who did express that the filing process wasn't as effective, but majority of them were average and above. And on the filing officer side, majority of the, pretty much most of the filers who filing officers who responded to the survey expressed a positive feedback or experience with the process. And this is just a way to get a general sense of what they think about this process. In order to provide better support and tools for the filers and filing officers, we also asked them for their feedback on what are the types of resources that they use in fulfilling their filing requirements. And this is the chart which shows the responses from filers, and I know the font is not very clear to see, so the responses we received, most of the responses indicated that they seek the support from filing officers in the departments. Some of them also indicated the Ethics Commission website, FPPC website, the FPPC form packet, and this just helps us understand that we need to prioritize some of these resources while we think about creating tools and materials for the filers. Moving on to filing officers, most of them responded that they, in the process of supporting this program, they used the Ethics Commission resources, the staff, information sessions, and the website to fulfill their duties. And this just gives us a sense of where we can better allocate our own resources and how we can put together information to support them. Moving on to observations and opportunities. So in the memo, you'll notice that we have much more detailed information from the respondents with their comments for different questions, but we wanted a way to quickly summarize some of the learnings from the process. So we've categorized some of the feedback into 4 areas: education, outreach, support, and technology. So these are some areas or opportunities that we can consider as we continue to enhance the program. So on the education side, looking at some of the comments from the filers, we understand that some of the filers have difficulty in understanding the filing requirements, or even understanding why this form is in place, why specific roles are required to file, and a few respondents indicated that they had difficulties in understanding the form, understanding the requirements for reporting. So this just gives us a better idea for creating instructional materials for them. So it just means that we need to focus more on raising the awareness of this program and the form and the requirements, using better outreach and support. So moving on to the outreach side of things, we definitely need to engage the departments and help and provide them the resources to educate their filers so that they can better understand the filing needs. Some of the responses also indicated, some of the filers indicated that they had difficulties. These were new filers, they had difficulties in getting guidance or understanding the requirements during the new hire process for the assuming office form. And there again, we can help the departments in standardizing or providing information that they can use to standardize their onboarding process to ensure that all the new hires receive information about this requirement and receive appropriate guidance. So that's something we can focus on. And we also received some feedback regarding information sessions. Some of the filing officers especially mentioned that that's been useful to them. So we want to continue and provide information sessions possibly throughout the year, not just during the filing period, so that we can ongoingly provide support for assuming annual and leaving office filing requirements. And to talk about the support side, we mentioned this a little earlier, providing more in-depth instructional materials with useful examples and scenarios that can help filers understand the reporting needs. Providing online training, this was a suggestion from one of the comments, providing more phone support, especially if the deadline falls on a Sunday and gets extended to Monday, maybe better to maybe provide them more support during or even beyond office hours, possibly. In-person support, especially for those who may not have computers or required setup to fulfill the requirements. And again, as Pat mentioned earlier, the one-on-one support and phone support, so just emphasizing on these types of support for the filers. On the technology side, looking at the comments, we did see that there were many filers who were looking for an e-filing option. So, looking at the next steps for e-filing for all is something that we can focus on. And ongoingly improving the system to make sure that any technical issues or impediments that filers may experience in the process can be eliminated. And again, providing web-based resources so that everybody can access information from their own machines, from wherever they are. So these are some observations from the process, and I think it's essential to get feedback from our users to provide better support for them and even to improve our program. So that's something we want to continue to do, and hopefully that will help us in the process as we think about e-filing for all as well. So that's it for our presentation. Anything else you want to add, Pat, to that? Or?
No.
Okay, all right. Are there any questions or comments or suggestions?
I'd like to just compliment you on the work in this. You've done quite a job, and I learned a lot from your analysis and on the reports of the 700s. You've very comprehensive, very thorough, and a lot of good work. Thanks very much. Commissioners?
I would join in the chairman's comments, but did you have a hotline so that the number that somebody could call if they were working on it and needed help?
They did call our office, the Ethics Commission line, but I don't think we had a separate line. Pat, do you want to comment on that?
We didn't have a separate line. However, last year with the reorganization of the Ethics Commission, which Leanne brought in, we have a team. So when someone called in, it wasn't just calling a direct line and asking for Pat. This time, there were a number of people who were able to answer the calls. So,
I'd like to join Commissioners, Commissioner Rennie and Chair Keene in commending you on the work that you've done. I think that the follow-up is absolutely critical to improving the processes going forward. And from a very specific standpoint, I'm looking at the chart number 2, at least in our materials in the appendix, the e-filing trend. Mm-hmm. I noticed that on day 0, I assume that would be April 3rd, there is a huge spike in the number of people who are filing. So to the extent that number of people could be moved forward or moved backward or forward in time, I think we could achieve a higher rate of compliance by the deadline, because the trend, as you noted, is on a downward slope from 99% to 90+% down to 88% this year. So to the extent that we could get those filers who file, and then there's from day 5 through 40, if we could push those people back to day 0, we could get back up to the 99%. And then the other thing to think about would be not getting people to file sooner, and then those who have missed the deadline, instead of waiting 30 days, but just to have the drumbeat of more messages. And I don't know if the fine is an incentive. If you file soon, you can avoid the fine. If you file day 1, it's this much, day 2, but it can really pile up as a financial incentive to file timely.
Thank you.
Thank you.
Commissioner Kopp.
One of the parts of the report which caught my particular interest is when the officers give you comments. And I'm just curious, because you're in the business. I'm not. All I do is file the reports. Do those comments run pretty much the way you expected, Ms. Peterson? In other words, some are angry, some are complimentary, and some are in the middle.
I expected a different distribution of the responses. I expected more complaints.
Uh-huh. Yeah.
These are individuals who are doing this once a year. The task is detailed. It requires a great deal of responsibility for something that's done once a year. And it can be a challenging process.
Yeah.
Especially when they're working with a department and we're asking them to execute certain tasks. So I expected a different response with greater negativity.
Good. Thank you.
Thank you.
Thank you very much. Excellent job. We'll take public comment now.
Chair, Commissioners, Friends of Ethics had a discussion about the enforcement issue and the penalties. You just mentioned that there is a rising fine that I think is $10 a day to a maximum of $100, and then at that point it goes over to the Secretary of State or a state agency. We wanted to suggest consideration be given as whether or not the Commission has the authority to prohibit an office holder from casting ballots if they have not filed their statement of economic interest. That it seems if a person has not filed to disclose what their financial interests are and continues to vote after the deadline has passed, that the public is not served well by that process. And a $10 a day fine to a maximum of $100 is not enough of an incentive. So we urge that you give that some consideration. Thank you.
Mr. Chair, have we ever examined that issue? Maybe Commissioner Rennie, you've got the longevity. Have we ever thought about establishing the law? You don't vote until you file your statement?
Not that I know of. I know I have personally wondered about when I see that 10% or so haven't filed at all, what happens to them? I mean, do we ever get to 100%, or do we have? But I think putting some kind of penalty on people who don't file is a good idea, because I agree the fine seems minuscule.
So do I. I agree too, and I wonder, Mr. Chairman, if the law permits such a penalty, number one, and if it does, number two, I'd invite submission of a possible addition to the law.
I can't see any reason why the law would preclude us from doing that in terms of an office holder who has a particular responsibility to disclose things as part of being an office holder and not doing it, that office holder is precluded from voting on the particular matters that come before him or her in that function as an office holder. I can't see it as any different from someone who, an attorney, for example, who doesn't pay his bar dues, can't practice law. You're suspended from practicing law. So certainly, just someone in this situation who's on X commission and doesn't comply with the criteria that are required of members of that commission, whatever, from saying that they can't function in terms of voting on various things. Nothing comes to mind that would prohibit it that I know of. Maybe someone could correct me.
Maybe I can ask the city attorney, but I assume this is state law. This is not San Francisco's campaign or good government. It's state law.
Yeah, so to your question, Commissioner Rennie, You're right. The Form 700 process is primarily a state requirement. The form itself is a state form. We can't alter that form in any way, for example. But it's an interesting concept. As far as I know, we've never looked at that option, so it's something that we could look at and come back to the Commission with if it wishes to move in that direction.
Yeah, I'd like to see a recommendation on that in terms of what we could do with office holders. Obviously, we couldn't affect state office holders, but office holders in San Francisco that are under the authority of the city and county. I'd like to see that.
Sure. I'm happy to work with staff on that.
No form, no vote.
Yes.
Sounds right.
Sounds like a bumper sticker.
David Pilpel. I think this is a novel issue. I don't recall in my experience with the commission that it's come up before. I think there might be some issues with those people who hold state offices.
There would be. We're not talking about state offices.
Right. No, but there are some that are considered state offices within the PRA framework, but serve in the city, 17,200 filers and various sorts. Anyway, but those that are merely San Francisco created positions pursuant to our conflict of interest code, perhaps we could do something if they hadn't filed within 30 days of assuming office or by the April 1 annual deadline. In any event, I found the report helpful. I think there was a presentation, and I hope that'll be put up on the website because I didn't see copies here. It also wasn't clear to me of the number of respondents to the surveys, what the population was. I guess the 138 responses is of the 505, but for the filing officers, that was 20 responses out of, I guess, about 50-ish. Yeah. So anyway, just including those so that we could see the percentage of response is helpful. And just finally, in past years, it was easier to find on the Commission's website the non-filers. I have found it more difficult. Maybe I'm not looking in the right place to get the names of the non-filers, but perhaps if we can, maybe staff can show me where, and if necessary, if we can make those more prominent so that we can encourage those folks who haven't timely filed to do so. The goal is not to highlight or shame, it's to promote compliance and get these forms filed on time so that people can act and can serve. I think that reduces problems down the road. Other than that, great presentation, and there certainly were some narrative takeaways in the qualitative comments, and I hope staff will look at those during the course of the year, particularly as we look to extending the electronic filing requirement to department filers, which will be a big step that's been talked about for some time with Stephen's help. We can't do it without Stephen. Thank you.
Thank you. Any further public comment on agenda item 4? Okay, we'll move now to agenda item 5, discussion and possible action on Ethics Commission records retention policy. There are attachments of May 17th, and we'll have a staff report and attachments.
Thank you, Commissioners.
Ms. Bloom should be congratulated on recently passing the California bar exam, one of the 38% who took it and passed it. Nice job.
Thank you.
May 12th is a day which will live in history.
It will. And June 1st, when Commissioner Kopp is going to swear her in.
Yes.
Also, Judge Kopp is going to swear her in to the state bar. That'll be an auspicious day as well.
Thank you. Thank you very much. I'm very excited to have passed, so thank you. So agenda item 5 is our updated records management policy. We brought this first to you in February, and we took some public comment in written form from folks. We also implemented changes that were recommended by the City Attorney's Office and the Comptroller's Office during their regular review of the state or the citywide recommendations for the records management policy, and implemented all of those comments into a revised draft, a revised version, I should say, of the records management policy. We consider this version to be final, but I'm still willing to entertain comments if the commissioners have struggle or have issue with anything. I think that probably the most notable changes are towards the end. As you'll recall, in February we included electronic communications in the records that should be retained, unless they do not qualify as a public record. Some additions from the City Attorney's Office and Controller's Office recommended changes include a section on backup tapes or similar archival systems. We are not obligated to search backup tapes or archival systems that are retained by the larger city infrastructure. Once they're deleted on our systems, and they're considered to be deleted. For pending claims and litigation, we're obligated to retain everything that's a litigation hold type of situation, and we have processes in place on our end to make sure that staff is aware when a litigation hold is in place going forward. We were required or asked to include updated information about records relating to emergency, disaster, and cost recovery, so I included that paragraph. And then actually at David Pilpel's suggestion, I included a section that gives staff discretion to retain to go above and beyond the policy for certain documents that we judge to be noteworthy but don't otherwise fall under the other categories. And also at Mr. Pilpel's suggestion, we've alphabetized the type of record under Part 2, so the record retention and destruction schedule is now alphabetized for ease of reference for the user, both at the staff level and at the public level when they're looking for the types of records that they might want to request. And so with that, we have sent this off to the various city departments that are required to approve it, the Controller's Office, Andrew, Mr. Shen, I should say, and the retirement system. And so we look forward to finalizing this, training staff, and welcoming ourselves into this century on records retention, or this decade, I should say.
Probably this century.
Yeah.
Yes, Commissioner Rennie.
On page number 3, under paragraph backup tapes D, go down about 5 or 6 lines, and it's backup takes instead of tapes.
Oh, I see. Thank you.
And then the question I have is, I didn't quite understand historical records. It says they're records which are no longer of use to the Commission, which because of their age or research may be of historical interest, can offer them to San Francisco. Historical records may not be destroyed. Why is that? If they're no longer of any use, you offer them to the library and they don't want them. Why can't they be destroyed?
Well, that's a good question. That's required by, that section is required by the actual ordinance itself to have a category for historical records. But as a practical matter, we did have a request recently for information that was not retained by the library and that we sort of had to put together because it was of a historical nature for all of the commissioners that have ever served on the commission and their appointment dates. So that would be kind of the information that we don't really use or track on a regular basis, but might be historically significant for the commission for us to retain as opposed to like the employment, DHR, or employment records.
Thank you.
Commissioner Kopp.
To the chair, are we going to be considering this for adoption tonight?
This doesn't require formal action by the commission. You're welcome to vote. It doesn't require formal action by the commission. You're welcome to vote, but it's a policy document at the staff level. So it's just presented for your information and for you to offer comment or suggested revisions.
Okay.
We don't have to act on it.
All right, but just let me nitpick a little bit.
Please.
On some of these, there are about 5 or 6 I don't understand. Sorry, the calendar of employees is the one we grappled with over some, I've forgotten what it was, some case we had last year.
Yes, Mr. Cava, the chief of
Yeah,
staff.
that's who it was. And what are we doing with that?
So we discussed that internally and decided to divide the calendar into 2 categories. The law only requires that the calendar the executive director keeps for commission business be retained. We've elected to voluntarily retain the calendars of the deputy director, and the unit managers.
Okay.
So everybody who's at a level of staff that would be making important decisions that affect the commission, the public can request those calendars, and we'll retain them for a period of 2 years. And then the employees that don't have that level of responsibility are not required to retain their calendars. So, for example, our staff assistants, our management assistants, those folks don't have to retain their calendars, principally because any meeting that they would be involved with, hopefully someone at the management level would be there anyway, and it would be on that calendar.
All right, and are you sure in your mind that this won't come back to bite us?
I hope so.
No, I know we
I feel
hope
confident
not,
that-
but I'm relying on the experience of staff, which is greater than mine, and I don't want, I mean, this commission can be a target. Don't do as I do, do as I say.
Mm-hmm.
All right.
so
You understand my point.
I do.
And you're still satisfied.
I am. I
All
don't.
right.
If somebody asks for a calendar, so if somebody asked for the management assistant's electronic calendar today, even under this policy when adopted, if that calendar has entries, those have to be disclosed because the record that's retained is a record. This policy only gives us permission to destroy those records. So if that employee were to leave, most employees don't go around deleting calendar entries, unlike Mr. Cava. So most employees don't go through their emails and delete them, or their calendar entries and delete them. But this policy would not require us to keep those calendars on our files after the employee left city service, like we would if I left city service or if Leanne left city service.
Yeah. All right. How about the certificates of the training? 8 years. Is that tied to the 6-year term, or what's the rationale?
I wanted that to be the same as the Sunshine Ordinance trainings.
Yeah, ethics.
Yeah, the ethics training and the Sunshine Ordinance trainings will keep for 8 years.
Uh-huh.
That has historically been the practice of the commission, so we have them. And in fact, I think the historic practice has been to never destroy them. So this
Okay.
just puts in a time frame for us to destroy them after, presumably, somebody who was elected to 2 terms would be out of office.
Okay, next page. Why, for contract payment records and contracts, is it term of agreement plus 20 years?
That's a good question. It's a long time. That is a recommendation or a requirement by the Controller's Office. And so our office is in order to get the Controller's approval, we have to have, that has to be the retention period.
Well, maybe I'll ask him. Next page, memorandum of understanding, same thing, why the 20 years?
We wanted to have, we didn't want to have a situation where, because of the contract term, we didn't want memorandum of understanding to be classified differently so that staff didn't have to keep track of multiple records retention schedules for different types of contracts. So we
Okay.
just made a discretionary decision to have the MOUs, which we enter into with other agencies, subject to the same terms as contracts.
And why the 8 years for sunshine ordinance declarations?
That's just the term that we decided, so that it's the same as the ethics certification. Everybody has to file that in roughly the same time. So we wanted to
All
have a
right,
full
so
set of
that's-
documents.
That's consistency.
Right.
Okay, thank you, Mr. Chairman.
Commissioner Chu.
Question about the compliance efforts to make sure that we will be complying with the requirements of these retention periods, because they're very many, they're various, and they're all different. So a policy is only as good as our compliance efforts on it. So what steps is the commission taking to make sure that we're managing to these different time periods?
We have, so this will be distributed to staff. It's already been distributed in draft form, so we will distribute the final version as soon as we have all the required signatures. They'll be required to read it and then show us that they've read it by signing a provision that says, I've read this and I understand it. We'll also be doing of staff so that they understand what it means to create a public record and what it means to be able to destroy a public record and what it means to save and archive public records correctly. And then we will update that training on an annual basis. We're going to start having all staff meetings. Our first one's going to be in July. So we will have those annual all staff meetings for that opportunity. On a technology side, Stephen is working on a lot of migration projects right now for our data. And built into those migration projects is a system for categorizing documents in the retention, in the category that they are set forth in here. So if it were a Category 3 document, you would mark it as a Category 3 document when you create it. And then the program will be able to delete on the schedule the documents marked in each category. So we're looking at a really streamlined technological solution to that question because we're trying to migrate everything to a cloud-based system, and we don't want to pay for storage when we don't have to.
Okay. Thank you.
We'll take public comment on this matter.
David Pilpel, I appreciate the work that's gone into this and taking some of my suggestions. I may have some other things here, some minor league issues. There's some language that hasn't been seen by the public until now on the disaster relief or disaster recovery issues. I'd have to go back, I apologize, and reread Chapter 8 of the Admin Code. I'll probably do that just because I'm that kind of a guy. I thought that where there's a border commission, that the border commission actually does have to approve a policy on the recommendation of the department head. So we can clarify the requirement as to who has approval authority in addition to the other city officers. I'm also not clear in the Category 1 permanent retention records if both permanent records and essential records can be imaged for purpose of retention and the paper copies destroyed. There's language to that effect regarding permanent records, but I don't see that language applying to essential records. And if it is, it should be, and if it isn't, then it should. I'm just not sure.
That's a distinction from Chapter 8.
Okay. I mean, among other things, this suggests that we should look at the city's record retention ordinance, which hasn't been overhauled in forever. I think it dates back to a long time ago. So there's that. Again, there are some minor tweaks I would make on the schedule, more in terms of the categories or the description of the record types, not the category or retention periods. But I'm happy to communicate that to staff if it's the pleasure of the commission to vote on this or just allow it to occur. Okay. Again, I would check what the legal requirement is in Chapter 8. But this really is good work, and I was hoping that we would get this to really a primo point so that this can be a model record retention or record management policy for all city departments, and that they can adapt it for their use. I think that there's been really a lot of good work done here that other departments need to replicate. Hope those comments are helpful. Thanks. And I'll have.
Commissioners, Larry Bush for Friends of Ethics. I think Mr. Pilbell recalls correctly that there was a point at which department retention policies were submitted to the Board of Supervisors. And at the Board of Supervisors, they were then adopted as a formal procedure. I don't know if that's still the case, but that was the case when I was playing around with that area. I would like to recommend that as you move forward with this as a model, you include in materials that you send to departments a copy of the city attorney's memo on the San Jose case decision from the California Supreme Court about retention of records, which included the fact that records on private communication devices like an iPhone or text messages also had to be disclosed and released upon request. And I noticed in some communities they ban officials who are in the course of discharging their duties, like members of the Board of Supervisors, from receiving texts about the issues that are before them in the process of making a vote, so that were I to text one of you about a matter before the Ethics Commission, that could be disclosed, or you could prohibit it altogether. So I think that's an issue to consider in the future. When you talk about the different categories of employees who have to retain records, it wasn't clear to me, in cases of someone submitting an immediate disclosure request, are all of those retained if they go to someone other than the top official? Some departments have a person who's assigned to that duty, or any other kind of request that could later figure in a public case. Thank you.
Thank you. Any further public comment on this item? Hearing none, we'll now go to agenda item 6 for continued discussion and possible action on Proposition J revision project. There's an attachment from May 17, 2017. We're going to have staff report and attachments. I might note that we've had 2 interested persons meetings on this. I was present at one of the interested persons meetings, and it was very productive, very revealing. So who? Oh, Kyle. Sorry. Go right ahead.
Sure. So just as a note, first of all, thank you, commissioners and members of the public. I think our goal here today for item 6 is just to sort of run through what we heard at the public comment, what staff heard. I've added a PowerPoint that I have here, and those materials are over there for any members of the public who need them. I also gave them to the commissioners. We did make a couple changes. I do want to note on anyone who has the board materials on item 6 on page 4, that timeline has been updated via the presentation here that we will provide to the public and post on the website after this meeting, and the commission members have the updated, revised version of that timeline. So going forward, we did hold public comment on the revised Proposition J proposal that we overviewed. Staff gave an analysis and overview of the sort of legal and policy considerations to that document at the April 24th commission meeting. And on May 9th and 11th, we held in-person meetings to get further public comment going forward. And I think we had a great turnout. We, as a staff, took a lot of information from those meetings, and we were able to extract some key issues going forward that I think will help us draft any suggested revisions going forward. There were a number of interests, or a number of individuals who presented, a number of interests represented at these meetings. And briefly, I just want to touch on sort of 5 highlights that staff took on this report. So we did notice that, in particular, public commenters were worried about and gave us anecdotal evidence as well as some written comment that we're continuing to develop about actual or perceived political corruption in the city of San Francisco. We heard comments they were particularly concerned with matters, anecdotally relating back, sort of a history was presented to us about instances of corruption in the city going back a number of years. In addition, and going along with that, is just the influence of money in politics generally. And then again, sort of connected with that, the undue influence of key political players in the city as opposed to the average citizenry. That was sort of a larger theme of the proponents of the proposal going forward. Alternatively, we also heard that the proposed draft of the Prop J proposal did seem complicated in terms of structure, and there was some concern that, as written, it would be confusing to the average layperson and to anyone who would be sort of subject to the provisions in the law. And lastly, but along with that point, is that there was points that were reiterated by a number of individuals about the potential constitutional concerns with some of the proposed provisions. All in all, I think it was a good and productive in-person public comment period. And as I said, we were able to sort of extract a lot of information that we will use going forward, and really sort of balancing the concerns of the all public commenters in that. And then just briefly going forward, I will introduce it, although it's sort of duplicative to the next agenda item. But along with this, we sort of did briefly mention to the public commenters that we do see a larger CFRO review project going forward, and Proposition J being, or the revised Proposition J being part of that larger CFRO review. As was stated in the annual policy plan that's been presented to the Commission, we see it sort of as the Commission's job to review the continuing strength and enforceability of the campaign finance ordinance. So with that, I will open it up to Commissioners' questions or comments.
Just one observation in regard to the addendums that you've given us. One having to do with the CFRO review timeline, and you have a CFRO review timeline that goes through August. Now, we have all along had, and we've emphasized it several times, that our Prop J revision that we've put together, we're going to vote on that at our June meeting, and that's what we expect to do. So we've been talking about that ever since we started this back in March or whenever it was. So my understanding is what the Commission wants for our June meeting is the final worded Prop J revision, which we will then vote on and send to the Board of Supervisors, asking them to pass it. The fact that there are CFRO things and all that, we're not, I myself don't see that as sidelining what had been our original thought process and what we've been talking about all along. Am I wrong on that?
I guess our understanding was that we would, staff's understanding is that we would sort of begin to draft those revisions and present those, but give the public commenters, as they expressed in those meetings, another chance to come back after we presented staff's recommendations, that they would have a secondary chance to comment. But we can certainly have a more formal proposal of recommendations for the Commission to vote on in the June meeting.
Yeah, I was at the, as I said, I was at the interested persons meeting and heard all of the comments, very interesting comments, and also I'm familiar with the comments that were made at the first time around. And I know there were people who had made their full pitch in regard to what we're doing and may not be pleased with what we're doing, and we're saying, well, push it on further. Let's have more discussion. And with all due respect for those people, what I was seeing there was kind of a filibuster in terms of let's put it off. I think everyone's pretty much been heard on this. And this Prop J, these are things that were originally passed 15 years ago and then were done away with sub rosa by a lot of questionable activity. And now we're putting them back. The Commission was prepared, my sense was the Commission was prepared to vote the thing through the first time we had it on, and I kind of put the brakes on and said, no, let's have some interested persons hearings and do some other things. So this timeline that you got here, that's not the timeline, as I see it. Am I wrong there?
I don't want to comment on whether you're wrong, but I think that the way we're viewing this at the staff level is that we already have a CFRO review plan. We're already going forward with that.
Right.
And it doesn't make sense from our perspective to try to introduce and manage two separate revisions of the same ordinance to the Board of Supervisors. And so what we'd like to do is this is our proposed timeline. so that we would be able to have the interested persons meetings in June that Kyle just announced, and he'll discuss further a couple of other things that we need to go through interested persons meetings on in the next agenda item. Then next in June, we would come back to you with an update about where we are in the process with those additional suggestions from the public, and that'll be a wide and open discussion with the public about what they would like us to do to make CFRO better. Our plan then was to come to you in July with a fully redrafted version of CFRO that includes.
Why we're not meeting?
Exactly. So you've bumped that meeting, I guess, to August, and so now we would bring the full package back to you in August. But we do need time at a staff level to really think about how all of these changes will interact with each other, compete with each other, and really comprehensively work together, because we're receiving a lot of different proposals right now. We've got Supervisor Farrell's, Supervisor Peskin's, Proposition J, our own desire to look at staff recommendations and what we've experienced through our own work, trying to work through some CFRO issues, some compliance problems. I have my own things I'd like to fix from an enforcement perspective, and we really would like to have a comprehensive product for the Board of Supervisors to consider, so that if the board rejects it, that comprehensive product is what goes to the voters. That we don't have to have two ballot measures or competing ballot measures, but just one comprehensive wish from the commission.
So you're saying, Ms. Bloom, that what you're asking, the staff is asking for, is that rather than vote in June, you would have a package for us to vote on in August.
Exactly. And then you would send it to the supervisors, who are recessed in August anyway. So if you voted in June, you probably wouldn't get any action on it until after August anyway. They would take it up hopefully in September, and we'd have a full debate at the Board of Supervisors this fall, which leaves us plenty of time for all of this to be enacted in time for the next election, which is June 2018.
Okay, well, we'll see what the commission. Yes, Commissioner
Yeah,
Chair.
so I am very much in favor of having a comprehensive review and discussion, fulsome public comment, and give staff the time to create a comprehensive set of recommendations for us to consider at our August meeting, or I guess it would be our August meeting. Because that way we will have asked and answered all the questions that we posed for Prop J, but also that will come up with Supervisor Peskin, Supervisor Farrell, as well as the concerns that staff has. I think this is the more prudent and ultimately, I think, more fruitful approach.
I think that's reasonable. It's just Supervisor Rennie and I were making the observation that sort of for the first time we were seeing August, when we had been talking about all through that we would do this at our June meeting.
She's convinced me.
I'm convinced
I think
too.
it makes sense.
Thank you.
I think it makes sense to do it all as one, something we've talked about in the past, that we do it piecemeal instead of, let's take a look at the whole thing.
Right.
Particularly now that we've got somebody on board like Kyle.
Right.
Who's got that, is his focus. And in August, you'll have had some more public meetings so that the public can feel that there was input, and go with the timeline for August to go to the Board of Supervisors with a complete package.
Okay, that's fine. I'll pull my horns back.
Great,
I just, I'd seen that, and it kind of set things up. But it's perfectly reasonable. All of us up here see it, even me as well. So.
I'll just jump back in here. So if you want to, it's on our PowerPoint now, if we can pull that up, but also on your materials, it should be slide 3 here, and you can't read it on there, but if you have the materials, you'll see that just for our own clarity here, we did plan on having something on Prop J, bringing something more focused back to you, but we wanted the public to certainly comment on that, and then, like we have said, bring a larger thing together. So I apologize for my confusion or our confusion, but We do have plan on have something more concrete for you and the public to comment at the June meeting related to Prop J, so people can see what this thing might look like, so they're not commenting on some abstract, something that's very nebulous. We want to bring something back based on public comment that we have received, that it is potentially confusing. So we do plan on bringing something a little more concrete back, but not having our full final thing back until August. I believe that's all that I have, Commissioner.
Commissioner Chu.
Yeah, Kyle, I have a question about Prop J. Does it make sense to come back in June with a standalone discussion about Prop J if you are going to be doing a comprehensive review and assessment of a CFRO overhaul?
We sort of heard public comments, and I think there was actually some that they wanted to see something more concrete that was not as sort of abstract and nebulous as the Prop J is as written. The red line version that you saw last time is sort of scattered. They wanted something that was going to look more like a final product. And I think we can present something that sort of breaks down some of those key areas, and it'd be just a proposal for you to consider, but at least it gives us and the public time to see something more concrete than what they have now. That's your prerogative, of course.
Sorry not to interrupt, Kyle, but if you can think of it as like giving you an opportunity to participate in the drafting process, so that when we bring what we bring to you for a vote isn't the first time that you or the public is seeing it.
Correct.
Thank you.
That's all I have on that item, Commissioners.
Any further comment or question by members of the commission? Okay, very good job, Kyle. We'll take public comment on this matter now.
Thank you, Commissioners. City Attorney's Office, Louis Dillon for Making San Francisco Great Again Coalition. And I'd just like to say that I was flabbergasted by your comments that you're going to put this off till next year now, almost 13 months away, 14 months away. Next June 28th, you're talking about when the election is, that it'll be ready sometime then. That's what she's saying. And we've just had comment 2 times down at Van Ness regarding this. And you're basically saying that means nothing. That now you're going to go ahead and talk about the CFRO process and talk about finalizing this even more. Each month this goes by means more corruption, more deals behind the public's back, more time for the gangsters with law degrees in City Hall to get away with their dirty business, and for you guys to sit there and allow it to continually go on, and then to allow the gangsters with law degrees in City Hall to perpetuate their gangsterism is unacceptable. That's why the city attorney's office is not to be trusted to regulate and govern themselves. They're the rats, the vermin with law degrees. Those are the people we want out of City Hall, the people that are bought off. But you don't seem to understand that. You seem to think the public is dumb and ignorant, but we're not. We see through you, we see through your processes, and it's got to stop. Dennis Herrera, for one, cannot be trusted to regulate when he himself is vying for political office in this shell of a city hall that it used to be. We already have Proposition J rules. Put them out, and then, well, let's amend it afterwards. But let's get this thing put through, and let's start to reclaim our government here in San Francisco. Instead of all this lip service, and you guys look so guilty up there, it's just amazing. You know, what's going on in this city is absolutely unacceptable. It should never get to this level where it's such pay to play and such corruption that people just don't even tune in anymore. They don't care what's going on in this city. And you guys are just free to run rampant right through it. Thank you.
I think I just want to...
Mr. Chairman, explain something.
Commissioner Cobb, I think I just want to correct the record for Lewis, who is misinformed on one thing. We as a commission are not putting this off to next year. We originally intended to vote on this in June. The staff has asked for some extra time. We're now going to vote on it in August to give them some extra time. It's not going over till next year. So that's not correct. It's going over for a couple of months. One of the reasons it's going over for 2 months is because our July meeting is canceled. We usually have cancel a meeting for summer vacations. So the staff is actually asking for just 1 more month. So, Louis, it's not being pushed over by us for a year. It's going over for a couple of months. I think that's an important correction that has to be made.
Mr. Chairman.
Yes.
Yeah, thank you for that correction.
Yeah.
I thought I was in the wrong venue. I thought I was in the wrong room. There's no municipal election until the second Tuesday after the first, or the first Tuesday after the first Monday in June of 2018. And the Ethics Commission, under law, makes recommendations, and those recommendations, I predict, will be delivered to the Board of Supervisors in August of 2017. That means, what, 10 months for the Board of Supervisors to evaluate those recommendations. And it is unjustified to accuse the Ethics Commission of complicity in an alleged scheme to ignore the people of San Francisco. Thank you, Mr. Chairman.
Thank you, Commissioner Kopp. Any further public comment? Ms. Lewin.
Good evening, Commissioners. Debbie Lerman from the Human Services Network, and I think I have the opposite perspective. At your last meeting, there was talk of a written comment deadline, I think on the 12th or 13th, and it was extended a month, giving us an opportunity to take a greater look at what's been put out and to not have to respond until June 12th. I was at the May 11th meeting. I appreciate Commissioner Keen's attendance at that meeting, and then I felt listened to. And we did express some comments about the complexity of this proposal and whether the average nonprofit organization would be able to understand what they can and cannot do without having to hire attorneys and things like that. So we would like to see it simplified. We have concerns about whether or not it would have create undue barriers to the opportunity for advocacy and expression of First Amendment rights. But being a complex proposal, we're still working through it, and we still believe there are other members of the community who have not yet taken the time to look through it yet. So again, that extra time is very much appreciated and valued. And I want to thank you as well for your agreement today to hold on and keep going through August. I think the strong opportunity for public participation can only make this better. We do support good government. We just want to see a balance with the opportunities for advocacy. So that's our perspective. And as somebody pointed out, the Board of Supervisors isn't going to touch this until at least September anyway. So it seems like this is turning into a much healthier process. And so I just say thank you for that.
Thank you.
Good morning, Commissioners. Excuse me, good evening, Commissioners. My name is Jonathan Minster. I'm an attorney at the Sutton Law Firm. Just one minor comment I have on the proposed calendar that the proposed timeline I'm looking at. A few people raised the comment at the interested persons meeting that written comments on Proposition J will be due on June 12th. I kind of would like to maybe hear from staff on when we could see revised kind of redline versions that would be kind of released on Proposition J. The concern being that members of the public will be forced to write comments on the revisions without having hard language in front of them, or will have a very short time frame from which to do that. The idea being, if the staff releases kind of new language on the 10th, that only gives someone 2 days to reply to those comments specifically. And it's my understanding that the June meeting will be kind of the kind of comprehensive meeting when we discuss this all in the open, and then I understand in August there will be a final vote. So the only comment I have to reiterate is as much time as possible for the public to have the actual language that will be looked at in order to submit public comments. Thank you so much.
Thank you.
May I
I think she wanted to, yeah.
Yes, Ms. Bloom.
Mr. Minster, our view of this is to present to incorporate the written public comment that we receive on June 12th into the draft that we will present to the commission. And so you will not see a revised draft ahead of June 12th, but rather in advance of the June 23rd or 4th commission meeting. And then you're welcome to submit additional public comment after that point. But right now, we ask that you comment on the proposal that exists so that we know how we need to look at revising it.
Good evening, Commissioners. My name is Peter Cohen, and I'm with the Council of Community Housing Organizations. And I primarily want to echo some of the comments that Debbie Lerman made from Human Services Network. We, like HSN, are a coalition of nonprofit organizations. We're all in the housing development and housing services delivery world, and we overlap quite a bit. And it's difficult to get folks' heads around these very complex pieces of policy, and that's what Debbie and I do as staff to our coalitions, is try to wade through these. But we want to make sure that the organizations themselves do understand the implications of what's being proposed. So the extra time for the written comments and to stretch your process through June, July, and the summer is much appreciated. I'd also like to just sort of make a friendly ask in advance if we have questions for staff to be able to check in, maybe even if some staff are available to come meet with some member organizations who can't attend these kinds of meetings. I think the more folks can understand what the objectives are and the very concrete proposals, the better. We had a challenging process with Prop C 2 years ago, and I think aside from all the technical things, there was the perception of a threat, whether that was real or perceived. And a lot of folks in nonprofit world are very intimidated about advocacy, and yet it's an opportunity they have, and we think it's a good thing to advocate for things and be engaged in the civic discourse and the political process. But it's very intimidating when these things come up, and that's not what nonprofit folks do. They're tending to do their mission-based work. So the more time we have to go through this, make sure that folks understand what it's about, how it has an impact on day-to-day work, and to allay those kinds of fears, I think will make for a better overall process for the measure that you ultimately relay to the Board of Supervisors. So I don't have anything specific about what you've got on the table other than to say the process and the time really do matter. Thank you.
Thank you.
Good evening, Commissioners. Anita Mayo, Pillsbury, Winthrop, Shaw, Pittman. I want to make comments regarding the current version of Prop J as requested by staff. First, Prop J is too complex and overly broad. Although defined in the ordinance, Prop J uses such terms as public benefit and personal or campaign advantage, which are not similarly used in state law. As a result, we don't have a history of regulations or advice letters to assist in understanding the terminology. It's also too broad in coverage. For example, all city board and commission members would be prohibited from engaging in fundraising on behalf of any elected city officer or candidate. This is a significant infringement on a board or commission member's First Amendment right to support or oppose a candidate of his or her choice. Prop J also unfairly targets developers and requires them to file special reports. Developers are already required to file detailed reports under the Developers Disclosures Law. Second, Prop J would result in unjust enrichment and encourage frivolous lawsuits. Prop J gives city residents the authority to bring civil actions when violations occur and to be awarded 50% of any civil penalties imposed against the violator. Provisions giving residents the authority to file civil actions should be limited to enjoining violations of the law or compelling compliance with the law. This provision also appears to violate the Equal Protection Clause of the Constitution by only permitting such civil actions against higher spending candidates and committees. Third, the goals of Prop J are met with current San Francisco laws. Current San Francisco laws already address potentially corruptive influences on public officials from campaign contributions, gifts, promised employment, and other emoluments. Current laws, among others, already limit contributions to $500, prohibit corporate contributions, prohibit city contractors from making contributions during specified time periods, prohibit lobbyists from making contributions and gifts and bundling contributions, prohibit gifts made for the purpose of influencing, prohibit gifts if the source is doing or seeking to do business with the recipient's department, or if the source attempted to influence a recipient during the prior 12 months, prohibit officers and employees from participating in any governmental decisions in which they have a financial interest or that would affect a prospective employer, and prohibit former officers and employees from communicating from 1 year or permanently with city officers or employees to influence them on behalf of others. Finally, courts tend to favor disclosure versus prohibitions. When laws prohibit First Amendment rights, courts have upheld those laws only when a government demonstrates an important interest and employs means closely drawn to avoid the unnecessary abridgment of those rights. Disclosure requirements are generally viewed as less restrictive than an outright ban. San Francisco has enacted significantly more disclosure laws than most California jurisdictions, including the lobbying law, the permit consulting law, the developer disclosures law, and the law requiring disclosure of information on daily calendars. In conclusion, the city does not need the additional restrictions imposed by Prop J. Thank you.
Thank you.
What organization are you from?
Your old law firm.
Huh?
Your old law firm.
Yeah.
Good evening, Commissioners. Elena Schmidt with Friends of Ethics. I just want to run through the calendar again, since this is the first time I've seen it and I want to understand it. That staff is asking for comments on what was presented at the IP meetings, and those comments are due June 12th. And as Jessica referred to it, it would be basically you're helping draft the final package. I would guess that you're going to get a range of comments and that your final draft is going to pick some comments or work with some comments rather than others. And I therefore think you might want to think about another opportunity for the public to comment on your final draft before it comes to the commission, either an IP meeting or an electronic IP meeting or something, because there will be disagreements amongst all the parties then. So that's something just to keep in mind before the June 26th meeting, as I understand it, that there could be another way that they could comment, or after the June 26th meeting, that the public could still comment before it gets to the August meeting.
That's exactly how it will work. You'll see a draft in June, and then we will not present a final until August. So in July and in August, we'll take additional public comment.
Is it going to just be written comments
Yes.
then? Okay. And then let's go to the new CFRO stuff, which, as I assume, it's the public financing. You're going to hold IP meetings on June 6th and June 7th. You're going to accept comments on July 7th. And this is going to be my comment's going to be the same, which is, are they going to be able to have an additional time after you've done your final draft to make a comment? And again, it's just for public input. Did you want to say? Yeah.
Yeah. So we're going to, the meetings that are scheduled for June 6th and 7th are going to be more comprehensive than just public financing, and there's not going to be a final version or review of the public financing stuff. We're putting that in front of the commission, hopefully so that they can comment on whether a larger review is necessary of the project, not a complete revision of the public financing system. That's too comprehensive for that short time span. We want to put it in front of them to see, based on public comment and based on some initial research, whether a review of the public financing system should begin.
And is that what you're doing in August?
That we are proposing having something for them in August, yes.
Okay, so that's not a final discussion. And the only other thing about when you vote on it and you send it over to the Board of Supervisors, don't forget you need time to develop the computer program. That's one of the reasons that T got delayed, was because of the development of the computer program. So factor that into when the election is, that you have the commission has to have time to develop the computers that's necessary. Thank you.
Thank you.
I wanted to kind of make an announcement in light of the last few comments that we've received, but I don't think I'm out of line when I suggest that Kyle would be welcome to public comment in written form at any time. So we don't have to host an official IP meeting or put a deadline on public comment. Like Mr. Pilpel did with the records management ordinance, if you ever see something that you would like us to consider, or you have comments or you have thoughts, please share them with us. We are very open to receiving public input on an ongoing basis.
Chair Keen, Commissioners, I just wanted to let you know that one of the issues that you've been raising is whether or not you can afford all of the work that will go into implementing Prop J. And in that vein, I've had discussions with the Controller's Office this past week and asked them to draft by the end of this coming week a budget of what it would cost to create a system that would allow you to interface between contracts, behest payments, travel, major donors, major developers, permit consultants, and all the rest of the lobbyists, so that you can track how the money flows. They won't be doing it other than providing a budget, hopefully by this coming Friday. There is some chance that the controller's budget can pay for some of that. In addition, I've been having discussions with MapLight, which is a very prestigious outfit that follows money, and they have just decided to open up an effort to track local campaign money and local political funds. They do it on the state level. They're nationally recognized. So they are now looking through the list of disclosures that San Francisco has enacted to see if they can't try and put something together to be of assistance. So just letting you know.
Thank you.
David Pilpel, some good comments received. I wanted to agree in particular with Peter Cohen and Elena Schmid's comments. In general, I think we should get this right rather than rush it. I think one of the problems a couple of years ago with that ballot measure is that there was a move to just do it. And I think this in particular has both the opportunity and the potential problem of both intended and unintended consequences. And I think now that Kyle is on staff, he will detect all of those things and let us know what's going on with it. Touching on Elena's comments, I think we should see where we are in a month at the commission meeting. If there's a desire or a need to have another round of IP meetings at the end of July or beginning of August, I think we should have that option. I don't think that would delay your consideration at the August meeting, but again, let's see what comments come in and what analysis the staff does. If that makes sense, maybe if there's enough process already in place, that may not be necessary. I'd also observe that the city's financial systems replacement project is underway, and so the controller's office and various finance people are going to be massively consumed in that for the next month. So That shouldn't delay our work on policy issues, but it may limit the availability of budget folks to comment on those matters. Otherwise, I think this process is going well. I look forward to Kyle's recap from the last two IP meetings and further analysis of these proposals as we go forward. Thanks.
Thank you. I would only observe that Prop C, although it may have appeared rushed, was a first-rate measure. Any further comment? Okay, we'll go on to the next one, which is Agenda Item 7, discussion and possible action regarding the following proposals for amending the San Francisco Campaign and Government Conduct Code. I won't read the whole bulk of the next couple of paragraphs, but they're there in the agenda, and we'll have the presentation on those now. The first one will be on the ordinance amending the Campaign and Governmental Conduct Code requiring disclosures, and that's going to be introduced by Supervisor Farrell. And I understand we have someone here from Supervisor Farrell's. Yes, sir. Would you? Kyle.
Sure. I'll make some just introductory stuff here. So because we did sort of get into this in the last agenda item, the agenda item 7 before we get into sub A and B, the Farrell and the Peskin-Ronan proposals. Again, just we put this memorandum together beginning just to sort of clarify, as we've now done via public comment and other things, just sort of introducing more formally the staff's proposed CFRO review in this larger, more comprehensive plan. So since we have already done that through public comment, I won't comment any further on that process. And as I said, we do have two sub-items, sub A and sub B, that will ultimately be part of this comprehensive review that's hit on some of the campaign finance related areas of disclosure and contribution limits. With that, I will give my introduction of 7A, the Farrell item, before Supervisor Farrell's staff member speaks. So briefly, Supervisor Farrell presented, or I guess I should say, the Commission received this report on January 10th, 2017, or the ordinance, I should say. And this proposal basically does three things within the category of disclosure. It's a ban on limited liability companies, S corporations, and other partnerships. And it requires them to disclose certain activities that they have in the city. Any of those organizations, those LLCs that are giving to certain committees, have to disclose to the Commission the purpose of the entity, the names of the entity's principal officers, and information about the funds that the entity has received through a federal, state, or local contract. In this proposal here, I sort of discuss the sort of legal and empirical evidence supporting disclosure requirements. As public commenters have noted, disclosure is usually the favored, or more recently at least, the favored political campaign finance related mechanism for reducing corruption and its appearance through recent case law development. I will have people note that have it in front of them that on page 5, we did break it down more closely, sort of some empirical evidence related to contributions from LLCs, partnerships over the last 5 years. And as the Commission can note there, that you see that you will note that there has been a fairly relatively limited amount of spending by these LLCs in the last 5 years. That spending is still substantial. It amounted to, and forgive me with the numbers, I believe it amounted to over $6 million in spending by those groups, although relatively a lot wasn't spent by those groups in terms of all contributions. It was still a significant amount of money. The last thing that I will note for the commissioners is that on pages 6 and 7, we do offer some sort of policy considerations for the commission to take, and just the reiterating sort of the breadth and scope of the disclosures, and for the commission to determine whether they believe that this disclosure proposal sort of meets the scrutiny standard that's been stated in Buckley, and whether these provisions sort of meet the goals that disclosure has stated, that they increase the informational interest of the voter, that they reduce, limit the instances of corruption, and that they increase the ability or allow the ability of enforcement to be enhanced. Additionally, and again, this is just reiterating our point of the larger CFRO revision project, we do want to promote with this proposal a more comprehensive review, and we believe that this proposal will be a significant part of that review. And lastly, as others have noted as well, we continue to have concerns or questions about the funding mechanism for the creation of the technological requirements to implement these proposals. So we would ask that the commission and the ordinance's sponsor consider that funding mechanism involved. With that, I will finish my comment on 7A.
Commissioner Rennie has Kyle.
I've turned to page 7 and the last sentence, and maybe you can tell me what that sentence really says.
In the recommendation section?
Yes, on page 7. Obviously, some words have been dropped somewhere, but on that last sentence.
I think it's just attempting to say that in order for the commission and commission staff to implement this effectively, we have to have some budget to implement the technological requirements that are going to be involved. If it's not supported by staff resources and a disclosure regime from a technological standpoint, it may be nice to pass this proposal, but it may be ineffective because staff will not be able to enforce it and administrate it effectively.
I think the language that you need there then, which was dropped, would be after the word practice, the words, in order that the ordinance is not rendered flawed and ineffective, that you need the funding mechanism in that prior language there. But after practice, you need, it drops off, the sentence drops off a cliff.
Are we reading a different sentence? This one that I see says, alternatively, costs associated with staff time required to process a manual disclosure system have not been calculated, as that approach within existing staffing levels could not ensure timely and effective.
Yes, above the recommendations, we have the wrong duplicative words there, yes. We could not ensure that it is implemented effectively.
All right. I understand it.
Yes, sir.
Good evening, Chair Key and Commissioners. Jess Montejano, Legislative Aide for Supervisor Mark Farrell. In front of you today is a campaign finance disclosure policy that we introduced last October, aimed at shedding more light on contributions from business entities to local political campaigns. As discussed in your staff report for this item, new disclosure regimes are becoming the front line of campaign finance regulation in the wake of the Citizens United decision. One of the only tools left at our disposal since this decision is to demand more disclosure from campaign donors so that voters and the public can have a better understanding of who is contributing and why. We all know that since Citizens United, business entities have been enjoying an expanded voice in politics at the expense of average citizens. The issue of lack of appropriate disclosure for business entities came to our attention last year when a local LLC contributed close to $500,000 to 5 separate ballot measure committees. All of the spending from this LLC was directed towards 5 ballot measures directly relating to this LLC's business interests. This LLC freely admitted in an October news article that the source of the contributions was money siphoned from taxpayer-funded affordable housing projects. To make matters more suspicious, public documents show that this individual filed incorporation documents on the same day using the same address for both of his business entities. And this LLC that I'm referring to has solely been used as a conduit for contribution to local politics and ballot measure committees. It appears to have no other real activity. Unfortunately, we have no idea of the true source of this LLC's contributions and whether any laws may have been violated. Yet, they're currently under the investigation from the FPPC, and I understand an ethics complaint was filed last year against this entity as well. I believe, and we believe, that this example illustrates why we feel it's necessary to have a proposal like ours on the books. Again, before I begin a brief overview of the policy, I want to make emphatically clear that we welcome any suggestions or ideas that may be used by this Commission to strengthen this policy. We believe this policy is simple and straightforward and will shed more light on the campaign contributions from business entities than currently exist in our current law. The policy would amend, again, the city's Campaign and Governmental Conduct Code to require local campaign committees to disclose to the Ethics Commission additional information for every contribution received from a limited liability company, S corporation, or other type of business partnership. The new disclosure requirements include the purpose of the entity. This is so that the public can clearly understand what motivations may be behind a campaign contribution. The second is the name of the entity's principals officers, so that the public can clearly understand the individuals behind this business entity or entities driving the campaign contribution. And lastly, information about any funds that the entity has received through any contract or grant from a government agency within the previous 15 years for a project located within our city and county limits. Under our proposal, committees would be required to disclose this additional information at the time they are required to file campaign statements with this Ethics Commission. And our policy gives the Ethics Commission all the flexibility to specify the form and manner in which committees must submit this new information. We believe, again, that this is a common sense disclosure reform policy. Will expose these potential dark money sources and shed further light on the influence they may be attempting to peddle. We believe that we must send a strong message that we can't sit idly by as a city when individuals or organizations seek to hide the true source of their campaign contributions from the public. We all have a right to know who is working to influence our government and local politics. Again, I want to thank you for your time tonight and for your service. Again, welcome any suggestions or ideas that you may have to our policy, and I'll be here on hand to answer any questions that may come up during the discussion. And thank you for your time.
Why don't you stay there for just a minute? Is it Mr. Andolano, is it?
It's Mr. Montejano.
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 Montejano. Oh,
Yes.
Sorry.
No problem.
For butchering it.
Okay.
Kyle, these suggestions, which are excellent, in my opinion, in terms of what they're attempting to address, how do they fit, if they do, in our Prop J regimen?
Well, as you know, part of the Prop J revisions are, it sort of, in addition to some bans and other stuff, but it does have disclosure regime. So this is just an expanded disclosure portion of the law. And this is part of the reason that we wanted to sort of bring it all together, is because as we expand disclosure and electronic disclosure in particular, we have to think about these things sort of comprehensively.
That's why I'm asking, from your perspective, in terms of the wording of what we have as Prop J now, could we encompass this or something substantially similar, equivalent to it, into Prop J? We could.
Yes,
okay.
I think so. It's just, this is again why if we just bring these things one at a time, we have to.
We're giving you lots of time.
Our IT staff has to sort of meld these things. Yes.
All the time you want. Huh?
I think working with our IT staff and perhaps other agencies to sort of bring this in line, I think we could develop something.
Okay. So, sir, in regard to your particular measure, which stands as a discrete measure, I would take it that Supervisor Farrell wants to introduce before the Board of Supervisors, and you're asking us to vote in favor of it. Would you have any problem with, you've heard our discussions about Prop J, would you or Supervisor Farrell have any problem with us just incorporating it within Proposition J and endorsing it and voting for it in that fashion, which we're coming up on, rather than separately? Sure. Or is there any benefit to us giving a separate vote
Sure. Unfortunately, yet I haven't had the opportunity to discuss that suggestion with Supervisor Farrell. I'm happy to go back and make that suggestion. On one hand, I could see the convenience of doing that. On the other hand, I think the public interest is served by having potentially a separate policy moving forward, to, again, bring some of these contributions from business entities to light in terms of more disclosure. So happy to bring that back to him, but unfortunately can't have a position right now from the supervisor.
For what it's worth, you can advise the supervisor. I recommend it be included in Proposition J. It'll have a better chance of passage.
Yeah, and I welcome that suggestion, and thank you. And maybe defer to City Attorney Shen, or excuse me, I'm forgetting your name, on kind of what the process entails for Proposition J, just since I'm a little unfamiliar. I understand it will come to the board. The board has a policy discussion and debate, and then I think by 2/3 measure, we vote to place that initiative on the
one of
ballot
the
or
things
not.
you might inform Supervisor Farrell about is that it's the intention of this commission on sending J onto the Board of Supervisors to tell them that if they do not pass it, and we're going to give them a reasonable amount of time, we will vote to put it on the ballot next year. And we've had fair success over the last couple of years with measures we've had on the ballot.
I recognize that
overwhelming
success.
support. So, so that might be something that would be helpful to the other supervisors for Supervisor Farrell to emphasize as well in pushing his measure. If there is opposition to it, that it's going to happen anyway, so they might as well get behind it.
Sure, like I said, that's a fair suggestion. I think Supervisor Farrell will be open to that idea, and I'm sure he would be supportive. But again, unfortunately, I haven't discussed that with him, so happy to take that back and send formal correspondence to staff and to the commissioners as well.
Yes, Supervisor Chu.
Mr. Montejano, I have a couple questions. One is getting into the weeds a little bit.
Sure.
The last bit is the requirement of disclosure of the amount of funds that an entity has received through a contract or grant from any federal, state, or local government agency in the past 15 years.
Sure.
And then on page 5, there's this great chart that lists the amount of contributions and the largest contributors. Do you have the information of how much money that these 5 LLCs have received in terms of government contract money?
So from what I can see here, I don't know off the top of my head. For the LLC that was in question, the Yerba Buena Consortium, I know that they've developed affordable housing properties in the late 80s. They haven't built anything since. Again, they freely admitted in an article that a portion of the profit that this individual got from refinancing one of his properties, initially paid for with a composition of taxpayer resources, was the main source of his contributions. He referenced having a $300,000 slush fund to use for this LLC's activity at their discretion.
So I would just suggest it would be very helpful, at least for me, and I would imagine for my fellow commissioners, to have that kind of information before us. It's not only the amount of contributions that they're making, but also like how much are they receiving from the San Francisco government in particular, but as well as other governmental entities. Not least of which is because it will then create a good record that shows that there is a harm that we're trying to address through the legislation. Of
course, welcome that suggestion. Happy to send, again, after my time here, to staff and to the commissioners, publicly available documents around the campaign contributions that they received and contributed.
And then my second question goes back to the funding issue. If you could go back to Supervisor Farrell and ask for his suggestions or his view on how we collectively, as the commission and or the supervisors, could fund and find the resources to be able to actually implement a disclosure technology and infrastructure to be able to make this effective.
Sure. I think maybe just to expand and comment on that point a little bit, I think this is a common predicament that many members of the board, not only Supervisor Farrell, Supervisor Peskin has the same issue on funding not being identified coming right after me, is oftentimes at the Board of Supervisors we pass policies and they don't have that kind of direct attachment for funds coming towards the policy, because we'd have to embark on what's known as a budget supplemental appropriation, going outside of our traditional budget process, which is an holistic approach to all the city city issues that we have. So I'm happy to talk with him about it. As former chair of the Budget and Finance Committee for the last 4 years, I know he's supported this commission and staff's recommendation for budget increases, and we'd be more than happy to work with staff and with commissioners to identify the true costs and to also find ways that we could advocate to make this policy successful. Because at the end of the day, we're not proposing this for nothing. We want this to be implemented. We want these new disclosure requirements to come to light for members of the public to understand. So we're willing to work in lockstep to find that. And again, we have a budget process that's coming up here in the next week and a half or so. The mayor's going to propose his budget on June 1st, and then it's in the board hands after that to have a discussion around the budget priorities and values that we want to see in that upcoming city budget.
So on that note, I would love to get Supervisor Farrell's thoughts on whether or not and his support on including a standing component of the Ethics Commission's budget every year of a ordinance-related slush fund that we could always rely on, because otherwise, we will have ordinances and really very meritorious legislation and ordinances that come before us but not have the resources or be scrambling or having to defer for 12 years or to 18 months. But if we could count on budget support every year, I think that we could certainly put that into the planning process from a resource standpoint as well as an IT standpoint, and then move a little bit more seamlessly to enact laws and then be able to get them up and running.
Yeah, of course, and I'm happy to take that suggestion back to the supervisor. I think it's a great suggestion. It's a predicament that we hear from the public all the time. As members of the Board of Supervisors, we deal with pennies in terms of our overall city budget. The mayor controls about 99% of that budgeting process, and we're dealing with about $25 to $30 million in a first-year budget and about $10 to $15 million on average in a second-year budget that, as a board, we're able to collectively come together and reallocate in terms of new spending or new priorities or new investments.
Okay, we'll take public comment on this.
And thank you very much.
Thank you, and thank Supervisor Farrell for us. Good efforts, excellent efforts.
David Pilpel, and I want to be sure that Jess is hearing my comments. I generally support disclosure, and as I think Anita Mayo talked about earlier, disclosure is generally a favored approach because it doesn't burden it. It merely requires information to be provided. I'm having a little trouble understanding this particular proposal. The way I read it, it defines business entity to only indicate 3 different types of business entities and not others. Maybe I'm misunderstanding that there are other definitions elsewhere in CFRO, but it appears to me that it's only covering these specific types. It's not clear to me, well, I guess the Commission would by regulation specify the form and manner in which the information would be submitted, but that leaves open to a lot of interpretation how that might occur and how that would occur in a timely basis given the other parameters of campaign finance law. On page 2 of the legislation at line 8, I think the first word should be received and not provided so that it's consistent with line 5 in terms of the amount of funds received. I'm not clear, and I think the staff memo was also not clear on why 15 years was selected for a look back. That seems to be an arbitrary time frame, and it just seems to me that the amount of burden that we're placing on contributors should somehow relate to a problem that we're trying to fix or address. And I'm not yet clear on where the 15 years comes from as a basis for that look back. On page 2 of the legislation, lines 2 through 4, the business entity's principal officers, I'm not sure how to read line 4, director. Is that any member of the board of directors? Is it some other director with or without portfolio that's not otherwise the executive director or the deputy director of that business entity? Again, it suggests some interpretation. To the extent that the supervisor is trying to capture this concern about refinancing, I'm not even sure that that would happen here because the original funds provided were that long ago, and the source, as was described, was the refinancing of some funds provided. So I guess I agree with the staff recommendation that this needs a little more time to sort out what problem they're trying to fix and how to fix it. I'm not averse to it, but I think we should try to get this right. And I hope, Jess, you'll take those comments. Good.
Thank you.
Good afternoon, Commissioners. City Attorney's Office. Once again, I'd like to thank the input so far and just kind of remind everybody that, it was by 90% that the people of San Francisco spoke up and had the civil grand jury regarding Proposition J. It was overwhelming due to the fact that, it was previously on the books here, much like it is in Sacramento and Los Angeles, but was dropped a decade ago from our city law. So that has enabled these loopholes for the vermin to jump through. And just playing the devil's advocate here, listening to the commissioners and the city attorney's office that's working on it, I kind of see somewhat of a filibuster attempt here to create a new loophole. And this loophole is we need more time. We need more public comment. We need more input. But the fact of the matter is it's just more time for more loopholes to be gone through. And it doesn't hurt to have this sooner rather than later, because these are important months running up to an election. And having nothing creates the sense that anything goes and nothing matters as usual. And so therefore, the scenario where we have to put it on the ballot, the timing is everything. And if we have to put it on the ballot at that late of stage of the game, then it's not really going to affect the elections. This will be another loophole that they can all jump through. And it's your job to close those loopholes and not have extended input that allows San Francisco and the city attorney's office to create more loopholes to jump through. That's what I see, playing the devil's advocate, as what's going on. We don't need technology. We don't need databases. It's just a few key people we need to watch here in City Hall and make sure they play by the rules that most major cities play by. Thank you very much.
Thank you.
Commissioners Anita Mail, Pillsbury, Winthrop, Shaw, Pittman again. As currently drafted, this proposed legislation will require San Francisco candidates, PACs, and primarily formed committees to obtain and disclose the following additional information about their donors who are limited liability companies, S corporations, and partnerships, their purpose, a listing of their principal officers, and specified information about federal, state, or local contract or grant information over the past 15 years for projects located in San Francisco. This information must be provided to the Commission at the same time that campaign disclosure reports are required to be filed. This proposed legislation imposes an incredible burden on candidates, PACs, and primarily formed committees to request and disclose this information. In addition, current campaign reporting forms and software would not accommodate such extraneous information. This legislation also imposes an unnecessary burden on potential donors who are LLCs, S corporations, and partnerships. Essentially, in order for these businesses to make donations, they would have to provide the candidates, PACs, and primarily formed committees with information going back 15 years, an unreasonable requirement. Laws which impose on First Amendment rights must demonstrate an important interest and employ means closely drawn to avoid unnecessary abridgment of associational freedoms. An ordinance which requires disclosure of detailed information from 15 years ago does not appear to be closely drawn. An example of a closely drawn ordinance would simply be to require any entity making contributions to disclose the true source of the contributions. That is already required under state law. The true source of donations must be disclosed. If it is not, that is considered laundering, and that would be an illegal contribution. Thank you.
Thank you.
May I ask you a question? Would you be satisfied if it were 5 years?
I don't think it's needed because I think laws already currently exist. You cannot make a contribution if you're getting contributions from someone else and then handing those contributions over as if that's from you or your entity. You have to disclose the true source of contributions. It's current law. It's been on the books for years, and that's under state law. And I think San Francisco may have a similar law. So I just don't think it's needed. Thank you.
Thank you. Any further public comment on this matter? If not, we'll move to 7B, which is the proposed ordinance of Supervisor Peskins, which also amends the Campaign and Government Conduct Code to require disclosure of various matters and things relating to committees and candidates and elected officials. Kyle?
Chair, is it possible we take just a 2 or 5 minute break? We've been here about an hour and a half for everyone.
Objection to that? No, I think that's a good idea. Why don't we take a 10-minute break?
SF Gov TV, San Francisco Government Television.
We're back in session as part of the Ethics Commission meeting of May, and we're going to item 7B on the agenda, Supervisor Peskin's proposed ordinance. And Kyle, you want to address that?
Yes, I will just do a brief introduction to this, and then we do have a member of Supervisor Peskin's staff here, and I will let him comment after that. So the proposal that staff reviewed here basically adds 3 additional requirements to CFRO in 2 distinct areas of campaign finance law generally. That is disclosure requirements, and it also contains a contribution ban for certain land use matters. Specifically, this requires city elective officials or their subordinates working on their behalf to disclose any contribution of $10,000 that they have solicited to a ballot measure committee or independent expenditure committee. Secondarily, there's a disclosure requirement that candidate-controlled committees identify persons who have bundled $5,000 or more in campaign contributions for their fundraising efforts. And finally, and alternatively, the proposal would prohibit persons with a financial interest in certain land use matters from making campaign contributions. It does require that the person with the financial interest in that matter disclose within 10 days of the filing or submitting of that matter to the commission. With that, again, just going through, again, I'm sort of re-outlining the points of disclosure, the legal and empirical sort of arguments surrounding disclosure. I additionally go through the sort of intermediate or heightened scrutiny that applies to contribution limits. I just want to note that there is a distinction in how you want to frame that level of scrutiny. The courts do it differently, but generally it's the closely drawn standard. I just want to point that out, that it is a, let's say, more difficult or higher standard to do the ban. I additionally want to point out that it is, although typically framed by courts as a contribution limit, it is a total ban, and that just goes to whether, in reviewing this, whether it is going to be closely drawn. Flipping back to pages 6, 7, and 8, I give the Commission some policy considerations there, similar to the disclosure considerations that we provided with the Farrell memo, but sort of expanding further again and noting that there is the additional requirement in this provision that there would be a complete ban for those persons with a financial interest in a land use matter. I also want to, as a final point, just note out that we again highlight the funding mechanism or lack thereof in the matter, because this is another disclosure provision that we would hope to roll into this larger CFRO project. We again would want to just note that this is an alternative and separate sort of disclosure process that we want to roll into a larger project. So just noting that for the Commission. So with that, unless there's any questions, I don't have anything further.
Okay, and we have the Supervisor Peskin's staff member here to address the matter as well.
Good evening, Commissioners, Chair Keene, Vice Chair Chu. Thank you for
hearing. Do you really mean that?
I do mean good evening. It's a beautiful night to be discussing campaign finance reform. My name is Lee Hepner from Supervisor Peskin's office. Thank you, Commissioner Kopp. I do want to discuss the 3 parts of this proposal because I think that although they are lumped into one ordinance, fairly distinct, and I wouldn't mind if the Commissioners considered them separately. Though they are proposed as a package. The first of those is to require disclosure of contributions that are solicited by city elective officers or their subordinates for ballot measure or independent expenditure committees. The disclosure requirement requires that the city elective officer or their subordinate disclose the name of the contributor, the amount of the contribution at a $10,000 threshold, the name and FPPC number of the committee that received the contribution, the date of the contribution, and I think notably on a theme that has been kind of throughout the measures tonight, the quid pro quo, and that is whether during the prior 12 months the contributor attempted to influence that city elective officer in any legislative or administrative action. Jumping to the second disclosure requirement, it's to shed some light on the activity of bundling, which is, as we define, a variety of activities, including requesting that another person make a contribution, inviting a person to a fundraising event, providing the use of one's own home for a fundraising event, and acting as an agent or intermediary with the making of a contribution. I think it's an awfully common practice in the field of fundraising. The disclosure threshold there is $5,000 and requires that committees that have benefited from bundling disclose the identity of bundlers, the contributions bundled by that person, whether the bundler is a member of a city board or commission, and again, on the quid pro quo note, whether the bundler has attempted to influence the officers who control such committees within the past 12 months. And it includes exceptions for candidates themselves and core campaign fundraising staff. And then the last of these that staff policy analyst Kyle Kundert went through in a little bit more detail is the prohibition on campaign contributions to members of the Board of Supervisors, candidates for the board, the mayor, candidates for mayor, and their controlled committees from any person with a pending or recently resolved land use matter. This, I think, too, is worth noting that there's significant overlap between this prong and some of the stuff in Proposition J, in as much as they both try to curb undue influence by people with pending land use matters, contributions from those individuals to city elected officials. Just some high-level notes. Well, actually, on a really granular level, in the staff report, one clarification, I believe that it's because these are amendments to Chapter 1 that these require a 4/5 vote of the members of this body, and that requirement is in Section 1.103. I think it says because this is an amendment to Section 1.103, but it's because this is an amendment to Chapter 1. But then I kind of want to respond to some of the discussion that's been taking place thus far and stress on some level the urgency that is before this body. And we talk a lot at the Board of Supervisors about various crises that we're facing. It's and very commonly we discuss the housing crisis and the crisis of homelessness and marginally housed people and people experiencing homelessness in our city. And I think that we would be talking about a campaign finance crisis if people felt the impacts of what was going on as directly. But, this is a bit of an abstract problem that we are facing. But it's a crisis nevertheless. And I want to stress that, it's important that this body forward something. And I like the idea of a CFRO project, a package, sending that to the Board of Supervisors, but in enough time that we can act on it accordingly at the Board of Supervisors for two reasons, and I'm considerate of two timelines here. One is that, certainly we want to have some of these reforms in place prior to next year's elections, and indeed that ship is already beginning to sail as we see candidates declaring for office, and other campaigns are going to start picking up over the next 6 months, gearing up for the June 2018 special election. So that's one timeline. And then also, should these reforms not pass in a manner fit to this commission's liking, then this commission, as Chair Keene, you've recommended that you will put something directly onto the ballot. And I think that there needs to be adequate time in order for that to happen at the June 2018 special election so that, if there's any time whatsoever to implement some of these reforms or to tee them up in advance of the November 2018 election, we can have some of that. But, without these reforms, I think our office is of the opinion that harm is being done without the knowledge of disclosure, without the benefit to the public of that disclosure, at the very least, the disclosure. We need to know what is going on. And I think that the staff report does a very good job at illuminating the value of disclosure in light of, certain restrictions that we have. The disclosure may be all that we have to really shed some light on the quid pro quo relationships at City Hall and in our political ecosystem here, and try to curb some of that behavior going forward. So with that, I would appreciate the conversation tonight. I appreciate your attention to the details, whether our thresholds are too high, too low. I thank you for taking this up and look forward to it. Thank you.
Mr. Hefner, one of the things that we're looking towards, and Supervisor Rennie and Commissioner Rennie and I were just talking about it, is that the ideal thing would be for us to pass this combined Prop J material that we have, which, if it can, encompasses what Supervisor Peskin has in mind, and get it to the board, and the board pass it. That's our ideal, and we hope that would occur. And if that did happen, it would be within the timeline of the things that you're concerned about and we're concerned about too. Get it going next year and be in plenty of time for the elections next year. But the fallback position is the idea of supervisors don't pass it, it's going on the ballot. There's just sort of as an observation, if your supervisor's measure does fit in to Prop J as Supervisor, and also Supervisor Farrell's position fits in, and we present that as a packet to the board, there might be some good chance that, given the fact that you have Supervisors Farrell, Supervisor Peskin, they both have different sort of wings of followers on the board, not followers, but people on the board who are in their camps, that it would go through. So that, I think, would be a pretty optimistic way to look at it. With that in mind, I'd ask you the same question I asked Supervisor Farrell's staff member. In regard to this measure, would it be important for you that this has to go by itself, or would it be something that would be fine with you and Supervisor Farrell for it to be also incorporated into the Prop J materials that we have and have it go up with the strengths that collectively I see it having?
Yeah, and as Mr. Montejano said, this is something that I've not asked Supervisor Peskin about directly. Yeah. However, I think we were positioning this package of legislation as recommendations to this body, and we'll take your recommendations as well. And that said, though, I think really the devil is in the details with many of these proposals, and it is about the time in which disclosures need to be made. It is about the threshold for disclosures. It is about what constitutes a land use matter, where that land use matter is appearing before, and those are the really intricate pieces that I think we will be, having more difficult conversations about when it comes to the Board of Supervisors. In the meantime, I would happily defer to the Ethics Commission's recommendation as to what it sees fit, and really in terms of prioritizing what this body sees and what staff sees and what you want to see implemented by next year. I think that is of critical importance.
All right, well, let me ask Mr. Kundert then. Could this also fit into the Prop J material, just as Supervisor Farrell's, you indicated?
Yep.
Good. Okay.
Again, it's very much similar lines.
Okay.
It's a lot of disclosure provisions that we want to get in that comprehensive package, so we get one shot at it.
Okay. Well, my observations of my colleagues would be that.
Good idea. Good idea.
So, one other thing I think I mentioned this to you when we talked about a week and a half ago. Supervisor Farrell is due some credit for Prop J, because for the Prop J material that we've been working on up till now, because when we wrote this, when we sat down, I sat down with the other people who helped write it, like Mr. Bush and others. we had a crib sheet of some of the things that Supervisor Peskin was proposing, and we stole liberally from those things. So it's already there, a number of the things that you've been talking about, and the rest of it, I think, dovetails in nicely.
Right, and I think that speaks to the overlap between these proposals and also Supervisor Peskin's 2 decades-long interest in campaign finance reform, which, I appreciate the history between this body and Supervisor Peskin and the ideas traded.
We're in sync, definitely in sync. So,
Mr. Hefner, so I'm very happy that you're open to working with staff on this, and I would just encourage you and staff to take a look at the outright ban from a constitutional standpoint, just because I want to make sure that whatever proposal we put together and send to the Board of Supervisors would pass constitutional scrutiny so that it wouldn't be struck down in a subsequent lawsuit.
Absolutely.
And then my second question would be the same question I had for Mr. Montejano. What, if anything, has Supervisor Peskin indicated he could do or would support in terms of finding resources for the Commission to be able to enact?
Yeah, that's a question that I'll have to run back to Supervisor Peskin with. And I think all of the supervisors have the same perspective or a similar perspective. I shouldn't say the same perspective, because there's quite a bit of disagreement among the supervisors in the nitty-gritty details. But, in as much as the mayor sets a certain amount of the budget and then the Board of Supervisors has a certain, pocket to take care of itself, I think that, we'll do what we can, but I really do appreciate in the staff report that it's, generally itemized how much staff needs to implement. I think it was $115,000 and then a $40,000 annual operating budget, and I think that that's well on our radar.
So, the point being that we can make great law, but it doesn't mean anything if it can't be enforced.
Absolutely.
Operationalized or enforced.
Okay, well, we'll take public comment now on this matter.
Those are my notes. Commissioners, Larry Bush for Friends of Ethics. There are some clarifications that I need to make sure that I understand all aspects of this. It refers to solicitations for $10,000 or more by a city elected official, but it doesn't cover people who are not elected officials. So think back to the city college, where the head of the city college was soliciting money for a bond measure and ended up getting convicted of a felony on that. Well, shouldn't this cover people who are not elected officials but who are acting in an official capacity? Take a look at Recology as one example, where you have a rate being set by 3 officials, none of whom are elected officials. One is the chief administrative officer, one is the head of the Public Utilities Commission, and one is the controller. They're going to vote on an increase at Recology that could mean anywhere from $20 million to $30 million in this year alone. Are they in a position to suggest to Recology, wouldn't it be great if you made a behested payment to so-and-so? If you look through Recology's contributions in the last 2 years, it totals about $85,000, and most of that was in amounts under $10,000, which is the threshold for reporting here. Most of it was in $5,000 contributions when you're talking to ballot measure committees. So I would suggest a review of actual facts on what is the average amount of money being solicited for ballot measure committees. I just chose Recology because they happen to give money for ballot measure committees.
And they give charitable contributions.
Yes, they also do that, but I didn't research that part as well. But you're right, they definitely do. And the same thing goes at Rec and Park, where the head of Rec and Park solicits money for the Rec and Park bonds, or Nauru soliciting money for the streets and sidewalks bonds. Since I'm on a bond oversight committee, I'm familiar with the fact that this is what goes on. So I think that you need to take a look at not just elected officials, but people who are acting in an official capacity. where they also have an ability to confer a benefit. Also, in the list of land use, I do not see the port listed specifically, and yet we know that the port is one of the richest areas for land use and exploitation. Our experience in the civil grand jury was when we issued our report on how the port decisions were made on allocations, it never went to the Port Commission. It was just a decision made by the port director, and our own report was never voted on by the Commission. So I think you need to take a deeper look. Thank you.
Mr. Chairman, I'd like to ask that those two suggestions be transmitted to staff to evaluate and present in legal form.
It's a good idea. I agree with that, Commissioner Cobb.
Commissioners Anita Mayo, Pillsbury, Winthrop, Shaw, Pittman. This proposed ordinance imposes unreasonable disclosure obligations on city elected officials who solicit contributions for ballot measure and independent expenditure committees. This legislation imposes a 24-hour reporting burden on the elected official to disclose detailed information not only about the solicited contribution, but also about whether the contributor lobbied the elected official during the past 12 months, and if so, details about that matter. The requirement to disclose such detailed information within 24 hours after the contribution is made is unreasonable, especially when the lobbying information is not even related to the election. The bundling section of the proposed ordinance is overly broad in its coverage. The term bundled generally means collecting and delivering contributions made by others to a candidate or committee. In the proposed ordinance, this term has been greatly expanded to include, among other things, simply requesting a contribution, inviting a person to a fundraiser, and supplying names for invitations for a fundraiser. Given the current definition of bundled, it will be impossible for a city elected officer to accurately report who has bundled contributions for his or her campaign. Unlike the typical situation where the bundler hands over contribution checks to the campaign, and the campaign thus knows who raised the funds, the proposed ordinance makes it virtually impossible for the recipient candidate to determine whether any contributions received by his or her campaign resulted from bundling activities as defined in the ordinance. The ordinance provides an exception from disclosure for paid fundraising staff, but the exception only applies to one person for each committee. This limit on the exception is not rational. If fundraising staff are paid to raise funds, it does not make sense for the candidate's campaign to have to disclose such staff as bundlers when payments to the staff must already be disclosed on the candidate's report. Finally, persons with land use matters are being unfairly targeted. A person who owns at least 10% or $1 million in a project or property that is the subject of a land use matter, and certain executive officers of that project, are prohibited from making certain contributions during specified times. This is overly broad and a burden of one's First Amendment right to make campaign contributions. In addition, whether or not any contributions are made, such persons must file a report with the Ethics Commission within 10 days of filing or submitting or receiving written notice of the filing or submission of a land use matter. Given the developer disclosures law already in effect, such required filings simply create unfair burdens on developers. Thank you.
May I ask a question, Mr.
Yes,
Chairman?
Commissioner Cobb.
What does the word bundle mean in election law?
Generally in election.
Jurisprudence, if at all.
Generally, in most cases that you read about or in most laws.
Well, I read about it in the papers, but
Right.
you're an attorney and so
Right.
am I. I want to know if it has any legal recognition.
It would generally have to still be defined, but the way it is generally regarded is an individual typically raises money on behalf of a candidate or official, obtains those checks, and hands them over to the candidate or committee. That way, the candidate or committee knows who the bundler is, and that's why there's been some legislation or concern about undue influence regarding the bundler. In the current legislation, the definition of bundler so widely defined that if you simply invite someone to a fundraiser, you don't know whether or not that person went to the fundraiser or not. But yet, if you invited that person to the fundraiser and you eventually at some point, 5 months, 6 months, a year down the road, get a contribution from that person, you're supposed to disclose them as a bundler. How would you know that? That's the problem with the broad definition of bundler in the ordinance.
How about substituting the word collection?
How does that, I don't see naming it if you still have all of the various definitions, inviting someone to a fundraiser, permitting your name to be used on a solicitation letter. I mean, solicitation letters go throughout the entire city. So if your name is on a solicitation letter, how in the world are you supposed to know that someone who responded to that solicitation letter and made a contribution, theoretically, that means that that's a bundler? How would you know that? I just don't see how this provision could be implemented.
I like the word collection.
I think traditionally we could...
More lawyer-like.
Well, traditionally in San Francisco we could put other names on it and other titles, sort of the Jeremiah Hallisey touch.
Thank you.
For those of us who are old, the Mo Bernstein
I was going to
approach.
think Mo Bernstein too, yeah. Okay. No one knows what we're talking about out there. All right, so we'll have further public comment.
David Pilpel, who says these meetings aren't fun? That was good stuff. 3 things. I think when Lee Hepner spoke, he mentioned special election a few times. I think he meant the primary election in June of 2018. I'm not aware that there's a special election currently scheduled. Second point, there are some definitions here that vary from the Supervisor Farrell proposal, that vary from CFRO currently. I think that's a good example of why it would be helpful to wrap this into the larger CFRO review program, because these definitions and provisions vary. In some cases, they vary appropriately because there are different provisions and different ideas. In other cases, whether it's a business entity or how you define a principal officer, should really be consistent throughout, and these different attempts don't necessarily harmonize in that way. And the third thing that I wanted to focus on is on page 2, the land use matter definition. Larry already mentioned the port. The port has its own building code that's similar but different from the San Francisco building code. I'm not sure why this proposal limits land use matters to a permit or variance and not a franchise or lease, which are different concepts in law. But this only speaks to permits or variances and doesn't limit it to private projects. If the intent is to only burden private developers, then I think that should be clear. I can see circumstances where one public agency is seeking a permit or approval, particularly under CEQA, from the planning department or some other department, and might be captured in this and their officers subjected to some sort of thing. I think that's an unintended consequence, and that's why careful review of the language of definitions is important. Again, if this is going to be broadened beyond permit or variance, there are other bodies in the city, including the PUC, Rec Park, the airport, others that have leases and other entitlement type actions that might want to be countenanced in the scope of a land use matter for purpose of these restrictions. But I think we need to be careful and circumscribed depending on what the intended behavior is that we're trying to capture here. I think this needs some more work, and I appreciate the work that's already been done on it. Thanks. Mo Bernstein, that was good. Thank you.
Henry Berman. Who else we got? Okay. Any further public comment on this matter? If not, we'll then go to the next item, which is item 8, discussion and possible action on information requested by Commissioner Kopp regarding the process to obtain independent legal counsel for the Ethics Commission. And I think incorporated with this, in this, Commissioner Kopp, is your specific inquiry about whether or not a matter is privileged, whether the existence of a report, just the existence of a report, is privileged. Or I'll let you go ahead and.
I will be short. I propose a letter be sent to the city attorney asking the question of whether the legal advice delivered to Commissioner Johnson was in writing or whether it was oral. I do so upon the basis of the law as reflected in the legal research memorandum dated May 15th by Jeff Pierce, our senior investigative analyst and a member of the State Bar of California. And it confirms what I was trying to express last month. Simple answer, is it in writing or is it oral? And there isn't any enforcement attached to that proposal, Mr. Chairman, but others can speculate as to the means and the circumstances in which it was provided, thereby leading, I am informed, to a denunciation of this commission by Commissioner Johnson.
I agree with Commissioner Kopp that the attorney-client privilege, the California attorney-client privilege, federal attorney-client privilege, extends to the content of matters between attorney and client. They don't extend to whether or not a particular form of something being oral or in writing is covered by the privilege, because that's not any kind of disclosure of what the content of the discussion was, and it's only the discussions that are privileged. So I think Commissioner Kopp's request is appropriate and is not in any way an infringement of the attorney-client privilege. I think.
I agree with your conclusion, but I am concerned that this equally is not an agendized item. That if we wanted to have a discussion about whether or not we should take further action, I think it should have been on the agenda.
I'll tell you what, I'll modify it. I'd request through the chair that staff prepare a letter for me to sign.
Okay.
If I could add
Yes.
one point of information for the commission. So at the ensuing Planning Commission meeting, following the Ethics Commission's April meeting, I think it took place a few days afterwards. Thank you, David. April 27th. On the agenda, when the inclusionary housing item was called, and some of you may be aware, Commissioner Johnson spoke to what the Ethics Commission had discussed 3 days prior. And in the course of that item, one of my colleagues addressed any potential conflict of interest concerns that could be implicated by Commissioner Johnson going ahead and voting. So perhaps that moots the request, maybe it doesn't. If Commissioner Kopp, you feel like you need to submit the request, that's fine. But there has been oral advice given by my office on this question. It's on a recording of the Planning Commission meeting on April 27th.
May I ask whether or not since it's oral and open advice, then it's not privileged and confidential. Was the conclusion that the individual did not have a conflict of interest?
That was the conclusion, yes.
That was the conclusion.
That was the conclusion of the city attorney's office, yes, on April 27th.
My observation is that would be a very unfortunate conclusion, and also a totally wrong conclusion. Now, I'm not putting it on you, Mr. Chen. I just speak as someone who, as a law professor, taught ethics and taught on the matters of conflict of interest for many years, and I think it sort of dovetails into one of the things that Commissioner Kopp had brought up last time, and which is on the agenda in terms of discussion of possible alternative legal advice for this commission. And I look over what the staff has provided us, and I see, for example, that San Diego's Ethics Commission does not use the city attorney. It uses separate, and I'm not casting any aspersions on the city attorney's office at all. Dennis Herrera is a fine city attorney, and I have a lot of respect for the office that I've worked with over the years. But I do recognize that the whole aspect of professionalism and ethics for attorneys is that an attorney cannot serve two masters. And if you have a conflict, if you have an attorney advising one entity or one person, and by advising that one entity or one person, it is in some way problematic for another entity or person, then that attorney cannot represent both of those entities or persons. That's basic in terms of the ethical nature of an attorney's conflict of interest. So what I'm going to have further discussions, and perhaps, and I think I'm going to have a discussion with Mr. Herrera about this, but my inclination is that what we should do is do the same thing San Diego did, and that is have a separate attorney other than the city attorney's office, mainly because the city attorney has to look out for city agencies, city employees who may be involved in unethical activities, and our finding of things regarding those agencies and activities could subject the city to liability, which the city attorney's office has an overall obligation to try and protect against. Right there, you have a classic conflict of interest. So that's where I'm heading at some point along here. And again, Mr. Chen, I'm not directing this at you, saying you're a bad guy or anything like that, and therefore we got to get rid of you as our lawyer. I'm just talking about the nature of the game here.
Right. If I could just briefly respond to the few points. I don't want to hijack the presentation here or anything. I mean, I guess one assumption underlying your point about this serving two masters, and maybe the primary underlying assumption is your assumption is that if the city attorney's office is working with separate city clients, we don't tell them what they don't want to hear. Quite clearly from the last meeting, you can tell our office is willing to tell city clients, city officials, city commissioners, things they don't necessarily want to hear. And they may need to do something a different way than the way they had initially proposed. Now, when we do that, we try to provide options. Instead of going route A, there are routes B, C, and D. That's what we try to do. Secondly, I just want to say that you are also another, I guess, underlying assumption of your point is that you believe for some reason that the city attorney's office is not willing to tell clients, be they a member of the ethics commission or some other city commission, that they do have a conflict of interest and they shouldn't vote on a given matter and an agenda or in a meeting. We have done that on countless occasions. I have done that on countless occasions. So we are willing to advise clients that they should not participate in certain matters where we think there is a legal conflict of interest under state law, under local law, on some other sort of law, whatever the basis may be. And I guess my third and last point really is that, our office has always taken the position that it makes sense for the city and all the folks who work for the city to have a single source of legal advice. That is so whether a member of the Board of Supervisors has a question, a person in the mayor's office has a question, a person in the city department has a question, they all get the same answer to that question. Now, they may go different ways with that advice. They may inevitably disagree on the appropriate response, what is the right way to legislate against that issue, but at least they all have the underlying same baseline legal understanding of what the issues are. And that's what we think is the primary and ultimate benefit of having a single attorney's office provide advice to all the various officials that exist throughout the city.
You know, Mr. Chen, I've been part of this discussion now for about 40 years or more, back when I was a public defender. San Francisco never did this, but many other counties throughout the state would have situations where you'd have a public defender and 3 people are charged with a bank robbery. And one public defender was assigned to represent all of them. And the arguments, and that was done in places like Santa Clara County right up until 1990, until finally the Supreme Court of California said, "Whoa, wait a minute." And the arguments were made that well, efficiency and matters, and they all have a joint interest, and they should put on joint defenses and stuff. Those arguments are the same, are similar, or they encompass the same arguments that you've put forward. But you still get the basic aspect of it, of one attorney having 2 masters, 2 different things tearing at them, and that is something that ethically should be prevented if it can be, particularly in regard to an agency like ours, where we're the Ethics Commission, and we're looking at ethical questions in San Francisco. I'm not going beyond us. I'm not saying every agency in the city and county of San Francisco should have separate attorneys, but I certainly think this one should.
Okay.
Yes.
Deputy Attorney Chen, I really appreciate your input just now, and I have a long experience in the corporate world where we had many discussions with our clients, with executives who wanted to have their own counsel, and they would want to engage outside counsel. And consistently, the general counsel and our staff would always say, no, we would engage counsel on particular matters that would be outside the purview or the expertise of in-house staff. But I deeply appreciate the rationale and the and the purpose and the benefits of having the city attorney provide advice, and I can see and appreciate what you just shared. I also think that the criminal context is very different, right, from what we do here. And I would like to ask, because the matter of Commissioner Johnson and whether or not there was a conflict of interest, if we could get a copy of the transcript of that advice being given, because I think that we, in the previous meeting, took it as an article of faith that there was we didn't have the opportunity to have a fact finding in terms of understanding what is her role, what is the history behind her engagement with Spur, and what is Spur, and what is their mandate. I think that we would all benefit from hearing or reading the transcript and understanding the analysis of the facts that the city attorney went through, and only then, I think, can we truly understand what really happened, because I think that we have gone down a path, and rightly so, I think, because we felt that it was exigent circumstances and we needed to send this letter. But now that we have the opportunity to get more facts, I think that it would behoove us to engage in that inquiry.
Yeah, our office would be happy to prepare a transcript for the commission.
Mr. Chairman, I know the argument for 40 years that the city has to speak with one legal voice. This commission doesn't administer health care. It doesn't be the administrator of building of roads and highways. Here's a public record somebody obtained and sent to me, January 25th, from a Nicole Elliott to a Francis, male Francis, saying Francis, Nicole Elliott is identified as Director of Legislative and Government Affairs, Office of Mayor Edwin M. Lee. Francis, can you please set this up? I don't know why Ken has to do it. Ultimately, this is about whether or not this commissioner stays on and whether or not she will have to recuse herself on issues that are impactful to the administration. And then later that day, same person, and now this is a different person, a Ken Rich, Director of Development, Office of Economic and Workforce Development. Hi, Francis and Nikki. That must be Ms. Elliott's nickname. Can we get something on the calendar with Andrew Shen next week? I promised Christine, that's the commissioner, we would all meet with the city attorney as soon as possible to discuss in more depth the likelihood of her having to recuse herself from items of the Planning Commission once she joins SPUR staff. Thanks. I'm going to have Andrew Shen hold that time next Thursday, 11 a.m. Did that meeting take place, Mr. Shen?
As the commission is well aware that we did advise or speak with Commissioner Johnson about these issues, and we did speak with the mayor's office about these issues.
All right, so that meeting with you didn't take place.
Excuse me, Commissioner Kopp, I'd like to finish my comment in response. So I don't have my calendar here, so I can't recall the date and time of the meeting.
All right, so that was the predicate for meeting with the planning commissioner before the issue was ever raised in April of 2017 at our Ethics Commission meeting by Mr. Bush and other people.
Mr. Rennie.
I would still like that letter drafted, and I'll come by tomorrow, Ms. Blum, and sign it so there's a written record here.
This agenda item was about the inquiry that Commissioner Kopp had about whether we should seek to get independent counsel as opposed to the city attorney, which I tend to agree with you that it would be best if we could have our own counsel either as a full-time employee or as a contract employee or some other. But as I understood the memo that the staff provided, that in order to do that, you would have to pass an ordinance. Is that correct?
You'd have to amend the charter.
But amending the charter, it's not something that we as a commission can put on the ballot.
Right.
The Board of Supervisors has to put it on the ballot, or we have to go out and collect 51,000 or some signatures. Isn't that right?
That's correct.
All right. So that, I mean, I'd be perfectly happy to say we should look at and submit to the Board of Supervisors a request that there be a change that specifically says the Ethics Commission has a right to have independent counsel, and see if we can get them to put it on the ballot. But it, you know, it's nice to talk about it, but there's a specific statute that said we had to use the city attorneys. So if we want to change that, let's go ahead and do what needs to be done to change it, because I do think it would be preferable that we have independent counsel, although I've got to say, as I said earlier, I mean, since I've been here since 2012, I have no complaints with the objective, fair, honest advice that we've gotten from the city attorney's office, and particularly in the Farrell matter. The help of the city attorney's office is invaluable in coming out and getting it resolved. So I'm not, it isn't done because I'm critical of the city attorney's office, but that I think it makes good sense, and there is merit to the idea the Ethics Commission, because of the fact that it's dealing with alleged wrongdoing of city people, that we ought to have a independent counsel. But the only way we can get it legally is to change the charter.
That's right, Commissioner Rennie, and I might add that I think it's possible for this Ethics Commission to have independent counsel, but still have the city attorney's office would still defend us in litigation. So your observation about Ms. Eisenberg's excellent counsel to us when we were a defendant, I think that could be a different matter. I mean, perhaps Mr. Shen would disagree, but in most structural arrangements where there's a general counsel that's provided to an agency, the litigation arm, the Attorney General's office or the city attorney's office, still represents that commission when they're sued.
Mr. Chairman,
Commissioner Cobb.
San Diego has already written the law for us.
I'm inclined to go with San Diego as well. It sounds like Commissioner Rennie's going in that direction. So at some point, I expect within the next few meetings we'll put something forward to get the Board of Supervisors to get the ball rolling to change the charter. That would be my desire, and it looks like it's moving in that direction.
Sure.
Okay, let's take public comment on the matter.
To clarify, Chair, you'd like something for you to vote on in June. That's what you're saying, or you want us to research with the Board of Supervisors?
It doesn't have, again, I'm a man who never hurries people, as you know before. So at some point in meetings coming up, let's do that. Let's have something on the ballot to trigger the whole idea of asking the Board of Supervisors to change the charter and to get the charter changed and have separate counsel, have the San Diego model be our model.
Okay.
Thank you. Mr. Bush.
Thank you, Chair Keene. A couple of thoughts. One is that there is an interim step that you could take, which would be to ask the city attorney to designate an amount of money for the Ethics Commission to have its own attorney at this time without waiting for a charter thing. There's no reason why you need to wait for that. That would be legally important. You're quite correct about that. But consider for one fact that the city attorney accepts campaign contributions from people who you may be investigating. In fact, a most recent review of the campaign contributions to our current city attorney shows over 50 contributions from people who have major land use planning. And you're sitting here talking about legislation dealing with disclosure from people who are doing land use planning. You also required by the charter to send referrals to the city attorney when they involve certain things. And according to the records that I have from the city attorney in the last month, you have 55 referrals that were sent over to the city attorney for their review on whether they were going to act or send them back here. So there is a different relationship here as compared to anywhere else, and there's a greater reason to want independence. I'll give you an example from the past. There was an election in which early voting took place in one specific part of town, despite a written letter opposing that by the California Secretary of State. And so the Ethics Commission sent to the Elections Department a letter saying you're in violation of the Secretary of State's directive that you do not have universal early voting. You're only doing it in one particular area, which was chosen for political reasons. And then the Elections Department came back with an answer saying, we're a charter city, so it doesn't matter what the Secretary of State said. As it happened, the city attorney for the Ethics Commission was the same person who was the city attorney for the Elections Department, and she signed both letters. And that's the kind of problem that you're up against, unless you have some independence.
I recall that incident about 1998.
Let's play ball.
Commissioners, Elena Schmidt with Friends of Ethics. The first time I came before you was because I was the foreperson of the civil grand jury that wrote a report on the Ethics Commission. And one of the things we recommended was an independent counsel. So thank you for taking this on. The part of our report, and I see it also in the memo that Ms. Pelham put together for you on this agenda item, is that there was a charter change in 2002, and that charter change allowed an outside counsel to come, boards, commissions, any department heads, if you talked to the city attorney and got the city attorney to agree to it. So, as Mr. Bush said, there might be an interim step that you could take without having to go through a charter amendment if you could sit down and talk this through with the city attorney. The Ethics Commission, I believe, has used outside attorneys twice in the history, at least the little bit that I know of it. I don't go back as far as some people. And so it can be done, it has been done, and you just want to expand it greater than that. So anyway, thank you for taking it on. I think it's a good idea.
Thank you.
David Pilpel, this is actually one of the more important things tonight. Someone asked about the transcript from the Planning Commission meeting. I was able to pull up the caption notes. They're on sfgovtv.org website. Go to Boards and Commissions, Planning Commission, and find the date of April 27th caption notes. They need a little cleanup, editing, but they do basically cover what Mr. Givner presented to that commission in this very room several weeks ago. With regard to the process, yes, a charter amendment could change the relationship with the city attorney and allow outside counsel. I think, rightly so, the Board of Supervisors should consider carefully that matter before proceeding to place such a charter amendment. I think Andrew gave you a very high-level overview of some of those issues about powers and duties and consistent advice, who is the client, how client relationships are handled in a multi-pronged organization, so that there is that consistency, and whether the commission and ultimately the city would be best served by having separate outside counsel on an ongoing basis, as opposed to the option for outside counsel on particular matters. I'm reminded not just of Prop F in 1997, but actually of the Tammy Haygood matter, when there was one body of government that was seeking to remove someone under civil service, and there was actually a clash between commissions, which required the city attorney. I can't recall now if the city attorney represented one side, but there certainly was outside counsel on the other side. There are existing provisions for due process screens, for ethical screens, for special provisions given a particular matter or something that comes up. I think all of that needs to be kept in mind here as you consider further this idea of outside counsel. And finally, I heard reference to a May 15th staff analysis. Was that some additional document that's floating around that was not made available to the public? Is there some additional document? And if so, is that a public matter? Is that attorney-client?
You can request it under the Sunshine Ordinance.
Okay. I'd like a copy of that. I think it should be made available. I assume it has some bearing on the discussion and was not provided as part of the packet. Thanks very much.
Okay, we'll now move to item number 9, discussion of the staff's enforcement report and an update on various programmatic operational highlights of the enforcement program's activities since the last monthly meeting. We have an attachment of May 17th of the enforcement report and attachment, which tells what has been done. I think the commissioners have any further inquiry that they want in regard?
I have an observation. Since I've been a member of the commission, we've gone into closed session to consider such a monthly report. I don't think it's necessary to encumber the public by going into a closed section, forcing members of the public to leave the room. I'd simply note that the document shows we now have a full complement of investigators, and it's too early to be picky.
That's true.
So we'll wait till next month.
I think that's a good, yes, next month would be great, but Judge, I think you're referring to agenda item 11. Number 9, we've always discussed publicly. I'm happy to entertain questions about the Bureau of Delinquent Revenue or our caseload data.
Yeah, I got that too.
I will just sort of preview what I think is the most irrelevant provision or part of the report, which is that I am undertaking a fairly comprehensive look at all the other enforcement processes that are employed at other ethics commissions, local and state, in California, and trying to take best parts of each of those and fold it into a new and updated enforcement regulations for this commission. And I hope to have that to the commission for its initial look at the June meeting. And I'll send it around to everybody within the enforcement program, and the city attorney's office will have an opportunity to review, comment, make sure we're complying with all the charter provisions, and then I'll bring you a new draft of that. So we'll have a busy June meeting, is the takeaway.
Mr. Chairman, I should supplement my statement by assuring the public that I'm satisfied progress is being made, and the Bureau of Delinquent Revenue is making progress.
Yes,
yeah.
With added scrutiny. It is moving.
Any further commissioners' comments, or we'll take public comment on this item then, if there is any.
David Pilpel, I appreciate very much the additional narrative in the BDR chart. I think that shows the progress that's been made in the last month, and if that continues with new narrative every month of actions, then hopefully those folks will be off the list sooner rather than later. 3 of the ID numbers didn't make sense to me. The Chris Jackson, there's a new number on the second page there. The Lynette Sweet number seems a little odd. But in any event, as I say, the additional narrative is good. This might also be an opportunity, since there's also an additional chart on the following page about outstanding installment plans, to maybe have this be the location for other individuals that have outstanding Form 700s or other fees and fines, kind of as we've been talking about, sort of everyone who's in a bad place with the commission, non-responsive filers, accusations, any number of things. So if there's one sort of central repository for everybody who's in a bad place, regardless of the reason, we might highlight that, perhaps with the number of days they've been in that status, and try to get folks out of that status and back to being a good, upstanding citizen in the city. It's a beautiful dream in any event. Thank you for all the good work of staff, and hopefully these numbers will start to go down now that the enforcement team is in place. We're expecting a lot. Thanks.
Thank you. As to item 10, in light of the fact that Ms. Pelham is ill, and item 10 is discussion of the executive director's report, I'd entertain a motion to put that over to the next meeting.
Actually, would just had a question. I don't know, Ms. Bloom, whether or not you have an update on the budget, because by the time of our next meeting, it will have already been considered by the Board of Supervisors.
Yes, I don't have an update beyond, nothing has happened since this was written. So the general update is that we were able to get everything that we asked for. We got 2 new positions. We're going to, the new organizational chart that we are going to deploy is on the back of your packet of agenda item 10. The main highlights are, you'll see on the far left corner, there's a new column for engagement and compliance. We were able to secure what's called TX, or change a position, upgrade a position in that program to Chief Programs Officer. It's a management series. It'll be exempt from civil service rules and report directly to Leanne. And that Chief Programs Officer will oversee the entire Education and Compliance Division. The new position that we were able to get is in that program is going to be an 1823 Education and Compliance Officer who has the skills that we think are needed in order to help really push that program with the new Chief Programs Officer into more of what you saw with the SCI Form 700s today. We want that level of work and that level of analysis to be able to be completed on a regular and ongoing basis in all of the different programs, in addition to effective communication and compliance to our stakeholders. The other new position that we were able to, the other new position we were able to secure is in the Electronic Disclosure and Data Analysis program. There will now be 2 1052 business analysts and then a 1053 senior business analyst in addition to Stephen. So Stephen and Jared are in that program now. They'll get 2 extra staff members. And that is because we are excited, and as excited as you and the public are, about the growing technological needs of the Commission.
For these 3 additional positions, is that sufficient? 2 additional positions, is that going to be sufficient to meet current workload, or would that also be sufficient for example, the Supervisor Peskin and Farrell's new ordinance proposals?
We think sufficient for those new proposals. We requested these staff positions knowing that Prop J was happening, that Supervisor Peskin and Supervisor Farrell had additional disclosure requests, and that those would just keep, the only thing that's going to happen is more disclosure. We don't anticipate people saying enough disclosure. So we wanted to be able to, at the staff level, handle that for now. And so this doesn't take care of the funding that would be necessary for the contractors to build those databases, but we think we can handle what's on the horizon with this staff, and we're very excited about it.
Okay, in regard...
I had one last question. On page 5, with regard to, two specific questions. One is around the investments in staff development and training. So it says that there's no new funding provided in FY18. Does that mean that there's existing funding in FY17 that is also in place for FY18 that's not going to increase, or there's no funding?
No funding.
No funding at all. Okay, and is that also true for the translation services?
Does it say no new funding?
Yeah, no new funding.
Yes.
Okay.
Yes, we were not able to carry through a training budget, basically.
Okay, and then for the new positions that are coming online, how much of, from an FTE standpoint, of a run rate is being budgeted? It's not 100% because
it's always 3/4. You're not allowed to even request to fill a position in the city until 3 months. 3 months after the fiscal year. I couldn't tell you what the policy is behind that, but essentially you're always running at a 3/4 deficit. But in addition to that, you have a fair amount of time before the position can actually be filled, as you've noticed. So we hope to have these positions filled by the end of the calendar year. That's our goal.
Okay. So certainly any salary savings could possibly be allocated to staff development and training.
Absolutely.
Okay. So do you have the overall budget number for FY18?
I do not. If that's not in here, I do not have that number. But I can get it for you tomorrow.
That'd be great. Thank you.
Any further discussion on agenda item 10?
David Pilpel, I think the last time.
Then I'll ask for public comment.
Very good. I think my last time tonight. I see that the policy plan is coming back next month to the Commission. I guess I would suggest that in the future that it not be as much of an annual policy plan. I mean, that can be a component, but it would be best, from my perspective, if this had like a 1-year look back and a 1-year look ahead. So every month we would add another month off in the future and take off something from 13 months ago. Because right now we were talking earlier in terms of the CFRO and Prop J work of that extending to August. July and August are not on the current chart. They're certainly contemplated in that work, but it would be helpful, again, if we had several months into the future and weren't just locked into these fiscal year parameters. That's my only thought for tonight. Thank you all very much.
Okay. We'll now move to item 7, which encompasses what Supervisor Kopp talked about relating to a possible closed session having to do with public comment on regarding the status of complaints received or initiated by the Ethics Commission. Does any supervisor, does any commissioner wish to have a closed session to discuss the matter?
I move that we drop agenda item 11 and just pass it.
Is there a second?
I'm sorry.
All right. He's moving that we just drop agenda item 11.
For today?
Yeah.
Yes.
It's been moved in second. All those in favor say aye.
Aye.
Okay.
You have to call for public comment.
Is there public comment on? No hearing. Seeing no public comment, hearing none. We'll now go on to discussion and possible action on items for future meetings. Well, we've covered a certain amount of those as we've gone along. Any commissioners have any thoughts about discussion and possible action on items for future meetings beyond what we've raised in this meeting, which is several things?
Nope.
Any public comment on that? Very good. I'll entertain a motion to adjourn.
Move.
Second.
All in favor? We are adjourned. Thank you all.
Thank you.